Sure, today's list, it has been fixed at 2 p.m. That we have decided to withdraw those cases by filing an IA. That IA may be called for, we have filed it. And at the same time, we have filed a different petition for taking up care of the whole thing. Those are not numbered yet, but that may be required for the purpose of adjudication today. And that may be called for along with this IA.
Today?
Today. It will not take time because first IA, I will withdraw the all. Then,
Okay. But not immediately at 2 p.m. because 2 p.m. we have another fixed matter.
After that,
thereafter.
immediately there. I am obliged.
Yes.
Yeah, Lordship, I need to mention for listing minor one IA minor on next Wednesday minor.
Or?
For injunction minor. It was your Lordship only directed to list the matter on last Friday minor, but the court has not been sit on the last Friday minor due to.
Today may not be possible on Monday.
No, next Wednesday.
Wednesday, okay.
3830.
Yes.
Lord, I'm paying for listing of a second appeal, Lord, on 4th of August, Lord.
For?
4th of August.
For?
Orders funds.
May I praying for listing for order, my lord, the 1st of August, my lord. Okay.
May I please, your lordship, to release application, your lordship, on 1st of August.
My lord, I would like to mention item number 37, lordship. For accommodation of at least 2 weeks, lordship, to filing some, I require some more instruction from Chavor Town Committee. Respondent number 1, lordship.
Item number?
37.
I am the petitioner, my lord.
I have taken consent of the other side.
I am the petitioner, interim order is there, that may be extra.
Okay. As agreed by learned advocates of both the parties, Restitution lays the matter on?
After 2 weeks, lordship.
After 2 weeks. After 2 weeks. Interim order possibly shall continue.
May I pray for a date, my lord? There is some urgency in the matter, my lord. May I pray for a date, my lord?
They are affiliate, let them first come because we have to respond otherwise.
On 18th August.
My lord.
My lord. Obliged, lordship.
My lord, I pray for listing upon IA, my lord. My lord, what happened in this case, my lord? The appeal is pending, but in the meantime, my lord, the writ is issued in this case, my lord. So I filed one IA for the stay, my lord. So may I pray to come out on Monday, my lord?
On Wednesday, not Monday.
Monday already we have.
On Tuesday, my lord. There is some urgency, that's why I'm praying. Tuesday, my lord.
Wednesday. Tuesday hearing.
Hearing day?
The writ is issued, that's why.
No, not Tuesday, not on Tuesday, Wednesday. Yes,
My pleasure. I beg to mention item number 9.
item number 9.
9. Today's list, your lordship. In this case, your lordship, I have found the important documents, your lordships. After filing of this case, so lordships, it is need to annex this document. So I draw this present.
Okay,
petition.
all right. Mr. Your good name?
S. Islam.
S.C. Sharma.
No, lordship. S. Islam.
S. Islam over here. Learned counsel for the petitioner submits that he has an instruction to withdraw his petition.
With
And
liberty.
he also tries for granting him liberty to approach this court again by filing appropriate petition. It is accordingly allowed. This CRPIO instance dispose of on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Obliged.
May I please, I beg to mention an MSc appeal, my lord, for listing on Wednesday, my lord.
In which column?
My lord,
In which column?
orders.
Order.
Hey, please, your lordship, an IA is pending in one RSA for stay of the RSA. So I may be allowed, I'm mentioning it for listing on 31st, your lordship. Because stay application is pending and the execution is fixed on 8th of August, your lordship. Thursday, your lordship, next Thursday.
Thursday, we have cases on 5th August. 5th
It will be too late, your lordship. Prior to that, your lordship,
When the next date is fixed?
on 8th, your lordship. 8th of August.
Okay. 8 days prior. 5th of
5th of
Fifth
August.
May I please, your lordship, we are for listing in IA, lordship. IA for releasing of 50%, lordship.
When do you want?
Thursday or
First
Wednesday? Huh?
On 1st August.
Next
1
week. Next week.
Sorry.
30, 31. Is that possible?
30
31.
30 July, 30.
Yes.
May lordship, praying for listing of a writ petition, lordship, matter otherwise pertains to bench 2, but lordship had fixed as part that when lordship was presiding over bench 2. So It's not been listed since May, Lordship. If any date,
When do you want?
should for listing, any
When?
date. Next week, any date subject to convenience.
Well, is it on
Hearing date.
hearing matter?
Hearing matter.
Hearing matter then 19th August.
Only.
May I please, your lordship? I beg to mention for a listing FAO 74/2023. This is a long pending matter, your lordship, and the respondent was died. And we filed our IA for substitution, but from last May, it did not list.
When?
Any date next week?
Next week.
Yes.
Take a date for me.
On 6th August.
May I please, your lordship? I beg to mention item number 23, password for the lordship. Any date of listing next to your lordship?
23.
23.
Your good name?
I Islam lordship.
Your name is not there?
Lordship, my senior is MM Zaman. It's out of station.
Islam Learned Counsel appearing on behalf of Mr. M.M. Zaman, Learned Counsel. Conducting counsel for the appellant, price for listing the matter after
Next week, any date, lordship.
Next week.
press for an adjournment of the matter. Accordingly, the pair allow matter stands adjourned for the day.
My lord, I beg to mention this matter which was not listed since 1.5 years. The connected matters has been disposed of, civil division matters.
When do you want?
Monday.
Monday.
Monday not possible.
I-
On 1st August. 1st August. Under which column?
Admission.
1st August.
Can it be on 30? It will be convenient.
30 we have given so many cases. 30 already given.
Already
So
some
many.
cases have been fixed.
Okay, it is on the 5 minutes proceeding. The connected matters are disposed.
Maybe we have to hear you, we have to pass the order.
No, opposite party, I have taken consent also.
Maybe
1st August.
1st of August. Yes,
Published.
yes,
If I may, my lord, I beg to mention item 30, my lord.
30.
Yes, my lord. Item 30 is a RSA, my lord, 107. If my lord recollects, my lord, the analogous RSA 106 came up a few days back. My lord, that RSA, my lord, is fixed on 8/8. My prayer is, my lord, even this matter may be fixed on 8.
8 August.
Yes, my lord.
Mr. GMTS Learned Counsel appearing on behalf of Mr.
Iqbal, my lord.
A. Iqbal Learned Counsel for the appellant price for listing the matter along with RSA number
106/2025.
106 of 2020,
5, my lord.
2025, which has already been fixed on 8 of August.
Yes, my lord.
Where is accordingly allowed, recess, I'll take this RSA number 107 of 2025 with RSA number 106,
Yes, my lord.
2025 and list the matter on 8 of August.
Deeply obliged, my lord.
Items from daily list for motion. Item number 1.
So this is a transfer petition of a matrimonial suit filed by the wife, who is the petitioner here. Actually, she herself filed that matrimonial suit before the Principal Judge Family Court for better, your lordship. But subsequently, she has come across some hardships and inconveniences, my lord. Now she is residing here at IOC Nunmati. So, and her husband, he is the resident of Chhattisgarh, and now presently he is the prostate at Nisha, Hyderabad. He is in the CISF, my lord. And the stage of the case is that this is the initial stage for his appearance. She herself filed a matrimonial suit there. But later on, my lord, some hardships and inconvenience so far. She is living separately from her husband, and she has a daughter who is studying in the Kendriya Vidyalaya in Unmati in class 12. And apart from that, her mother, she is the dependent on her because she has no brothers.
Originally, the petitioner was belonging to Borpeta
Her
district.
parental house is there,
Okay.
Borpeta.
Now
And
he
they are,
has shifted from Borpeta to Guwahati.
yes, she has shifted. And my lord, so far, her mother is concerned. She was living there, but what happened? Now her liver cirrhosis, that disease has been detected. I have annexed some documents at page 23 that she is undergoing treatment at AIG hospital. 23, page 23, my lord.
Okay.
So,
Heard, Mr. Let notice go at this is that.
yes, my lord, notice may go. And apart from that, proceeding may be also, it's my proceeding, my lord.
Heard Mr. D. Bora, learned counsel for the petitioner. Yes. Application under section 24 of the Code of Civil Procedure is prepared by the petitioner for transferring the case. Link TS FC 38 of 2025 under section 13, certificate 1, certificate small I dash A and 13(1) Roman 1 of the Hindu Marriage Act 1955. From the Court of Learned Principles as Family Court Porpeta to the Court of Learned Principles as Family Court Kamrup M. Assam. Guwahati, Assam. Mr. Bora, learned counsel for the petitioner submits that the petitioner is the wife of the respondent and she has instituted the title suit. Being title suit number so and so before the Court of Learned Principles as Family Court at Porpeta. And at the relevant point of time, she was residing in her parental abode at Porpeta, and now she has shifted to Guwahati. And she has one school-going children.
Yes, my lord.
School-going children,
Daughter.
and also she has a ailing mother with her and residing at Guwahati, and it will not be possible on her part to pursue the matter in the Court of Learned Principles as Family Court at Porpeta, and therefore she tries for therefore the TS MFC number so and so may be transferred from the Court of Learned Principles as Family Court Porpeta to the Court of Learned Principles as Family Court at Kamrup M. Guwahati. The submission of Mr. Bora, learned counsel for the petitioner, needs further consideration at this stage. Notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered books with AD and also by usual process. We can have come to the list after 4 weeks.
My prayer is there, my lord. Page 11.
And taking note of the submission of Mr. Sharma, learned counsel for the petitioner, and also considering the facts and circumstances from the record, further proceeding of PS and FC 38 of 2025, pending before the Court of Learned Principles as Family Porpeta stands state will returnable data. This after 4 weeks.
Much obliged.
Item number 2.
Lordship, I had filed a petition in the family court, one, Kamrup Guwahati, your lordship, praying for restitution, for a decree of restitution of conjugal rights, your lordship. The petition, your lordship, was filed back on 12/12/2023, your lordship. And thereafter, your lordship, on 14/3/2024, your lordship, notice was issued, respondent was asked to file written statement. Your lordship, the respondent didn't file written statement on 27/9/2024. She was granted the last chance to file written statement. She remained absent again. Then your lordship, ex-parte proceeding was initiated against her. She then appeared, your lordship, and again ex-parte order was vacated. Again, after that, she started being absent, your lordship. And what happened again, your lordship?
No, see, there's a number of medical documents have been enclosed.
Yes.
And considering these documents, the learned trial court has allowed the time
Yeah, yes, your
to
lordship.
file a written statement.
Yes, your lordship. Now the thing is that, your lordship, that ex-parte order was set aside. She was allowed to file written statement, your lordship. Now,
Now, what is your prayer here?
yeah, your lordship, I want that, your lordship, if she doesn't file written statement, your lordship, the the proceedings should move on, your lordship. It has been already 1 year, 7 months, your lordship. Your lordship, she has not even filed written statement, and even I have filed the evidence, your lordship. And she has been playing this delaying tactics for a long time. And the last order suggests, your lordship, 36/2025, same thing, your lordship. Again, she has not filed written statement. Again, ex-parte proceeding has been dropped. And from my earlier experience, I know, your lordship, again on the next day, she will come with an application for setting aside of ex-parte order. Again, she will delay the matter for another 6-7 months. So, sir, so my lord, this things has been going on for a long time. So I'm praying for a direction, your lordship, at least to expedite the matter before the lower court, your lordship.
Tell me under which provision of law I will issue such direction to the learned trial court?
No, lordship, I'm praying for your lordship, your supervisory, your lordship, jurisdiction, your lordship, under Article 227. Because your lordship, if your lordship,
You see, on last occasion, she has enclosed some medical documents for which the learned trial court has allowed the petition.
yes, your lord, that is on 2/4/2025. 2/4/2025, your lordship. Thereafter, she again remain absent, your lordship. That order cannot be annexed here, but I have an order of 36/2025. May I place it before your lordship, your lordship? Same thing happened again, your lordship. This order of 36/2025, your lordship. Same thing again happened, your lordship. So your lordship, again on 1/8, again she will come, your lordship. So at least, your lordship, an order, if she doesn't file a written statement on 1/8, your lordship, she may not be allowed another chance, your lordship. Again, she will drag it for another 6, 7, 8 months, your lordship. For 2, 3 years, she will continue like this. She will not appear, your lordship. And same thing has been done in other proceeding also, your lordship.
No, you tell me whether exercising the jurisdiction under under Article 227 of the Constitution of India, this court can issue such a direction to the trial court, not to accept the WS and to.
No, your lordship, I am not, at this stage, I'm not saying that, your lordship, her WS may not be accepted, your lordship. But on 1/8, your lordship, again, if she comes, your lordship, again, she doesn't file a written statement.
No, this application is not against any order.
Yes, your lordship. Lordship, I am primarily here only because, your lordship, this petition has been going nowhere, your lordship. She has been remaining absent, your lordship, all throughout since.
No, you challenge the order by which her petition was allowed.
Your lordship, your lordship, on 2/4/2025, your lordship, her ex-parte order, the proceeding was set aside, your lordship.
You challenge that order? Being illegal or arbitrary? In exercising jurisdiction under Article 227, this court can direct the trial court not to accept the WS.
Your lordship, if I may allow, I may be allowed to wait till 1/8, your lordship, the next date of hearing, your lordship.
Maybe. What would happen there? If
Your lordship,
could allow the petition?
Lordship, again, if your lordship, she comes and file another petition for vacation of
Then
ex-parte.
you can challenge that order.
Yes, your lordship.
You withdraw this petition.
Your lordship, let it be pending, let it be
Why?
pending in
Why?
1/8,
What
your
order
lordship. I'll file an
must be
additional,
at time?
I'll file an additional affidavit, your lordship. A challenge, annexing that order.
This petition, in this petition, you have not challenged any order.
No, your lord, I have challenged only that the learned judge of the family court has been delaying this matter, your lordship, and has not moved forward, your lordship.
Better you withdraw this petition, you challenge the order if the learned trial court again allow the respondent to file the WS.
Lordship. Lordship.
Pardon, sir,
I have seen.
learned counsel for the petitioner. This petition stands a disposal on withdrawal, granting liberty to the petitioner to approach this court again by filing appropriate petition.
Item number 3.
Lordship, may I get the certificate copy of that?
Okay, yes, return the certificate.
Right, please, your lordship.
Mr. Seth, where is your affidavit?
My lord, I could not file, my lord, some time may be granted to me.
Okay, Mr. MSA, Learned Counsel for the petitioner submits that he may be granted some time to file the affidavit. That is accordingly allowed.
My lord,
This is a
it
listening
may be,
matter.
it may be second week of August, my lord.
Second week of August,
6, 7, like this.
6, 7,
On 8 August.
8 of August.
Apply the rest.
Item number 4.
Lord, may it please your lordship. Well, the respondent has plaintiff filed a commercial suit for recovery of rupees 40 lakhs and odd. My lord, the being defendant, we filed a written statement. Now, the plaintiff, my lord, filed one petition under order 38 rule 5, directing your petitioner to furnish security. And on the basis, and that too, my lord, on the basis of newspaper item. As your lordship is aware, the newspaper report is not admissible in evidence. Nonetheless, my lord, the learned trial judge, how he has passed that order, I'll just take your lordship to that. At page, my lord, 91.
Yes.
Order dated 19/3/2025. Both sides are duly represented. The miscellaneous case has arisen out of a petition.
No,
hearing
not
on-
necessary to read out. I have gone through it.
My lord.
You pointed out which part of the order is wrong.
Right. Your lordship may kindly, the last, I'll take your lordships to paragraph 14, page 94. Heard both, as your lordship got that.
Got it.
Paragraph 14, my lord. Heard both sides, it appears that it is admitted that there is some outstanding money of the petitioner which is to be paid by the opposite parties. I have gone through the citation submitted by the learned counsel for the opposite party. The first case which learned counsel for the opposite parties has referred deals with the scope and object of order 38 rule 5 of CPC, which is equally applicable in this case. The second case referred in respect of admissibility of newspaper contents is in respect of a criminal case. The same is not applicable in this case. Though the outstanding amount is disputed, my lord, I'll stop here. Now, the learned trial judge has said, since that case was a criminal case, therefore the rigor of section 78 and 81 of the Evidence Act will not applicable if it is a civil case. That is not correct at all because the division bench has already clarified that. My lord, I will take your lordship to that first. My lord, I'll hand over to your lordship this. I'm having the one copy. I'll just read the relevant part, that is paragraph 7, 19, and 21. My lord, I'll read slowly, my lord. Paragraph 7, that the statement made in paragraph 1 to 5 are true to my knowledge and information derived from newspapers records of the case, and rest are humble submission before the honorable court. Such affidavits do not carry any conviction. They fail to bear minimal requirements of Order 9, Rule 13 CPC. Then, my lord, I will skip to the next para. Order 19, Rule 3 CPC, the Supreme Court in Shivaji Rao case, that is AR 87 Supreme Court 294, has very categorically and clearly laid down that where evidence were reduced by affidavit, such affidavit must be properly verified, either on personal knowledge or from other sources. But the basis of such knowledge or source of information must be clearly stated. Order 19, Rule 3 CPC of the must be strictly observed. Incidentally, this was also a case of malpractices in examination. Then, my lord, I will take your lordship to paragraph 14. Now, coming to the allegation made by the writ petitioner appellants, assuming for the sake of argument that there is a germ of truth in this allegation, although it is only an assumption, the respondents have very emphatically and categorically denied these allegations. Taking these allegations on their face value, the question is, who are the persons making these allegations? Those who appeared at the competitive test and failed therein, those who in their self-estimation and valuation consider themselves to be far better and superior to some of the candidates in the select list. It is their self-estimation and evaluation. They are free to do so, but having offered themselves to be evaluated, and assessed by the State Public Service Commission, the fact remains that they have not emerged successful. This glaring fact cannot be lost sight. They are trying to build up their case with the support of certain news items and press clippings. Evidentiary value of such material has already been discussed above. This contention is in the realm of mere suspicion having no factual basis. It has to be kept in view that there is not even a whisper in the petition about any personal bias of the members. Then, my lord, para 19. This will be important part, my lord. Now, adverting to the legal position as regards newspaper report and comments, Section 60 read with Section 63 of the Evidence Act itself provide a complete answer. Of course, it deals with oral evidence and in writ petitions. Evidence by affidavit is permissible, and we have already seen above the state of affairs and the affidavit filed in the manner. Law requires directory 1, that is to say, if it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. If it refers to an opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds that opinion on those grounds. The least that was expected of the writ petitioner, appellants in the circumstances of the case was to file a separate affidavit sworn by someone who holds the opinion which has been referred to in paragraph 18 of the appeal memo. At the rate the appellant wanted to rely on these news items and press clippings, their affidavit in support should have been more precise and strictly applying with the requirements of law, which is undoubtedly not. The Supreme Court had occasion to deal with the evidentiary value of news item published in the newspapers in so-and-so, 1969 Supreme Court. There was a case where a speech attributed to Mr. George Fernandez is published in the local daily from Mumbai, the Maratha. The Supreme Court ruled out the news item, observing that it is the function of the newspaper to publish and further held a news item without any further proof what had actually happened by witnesses is of no value. It is at best second-hand secondary evidence. It is well known that reporters collect information and pass it on to the editor who edits the news item and then publishes it. In this process, the truth might get perverted or garbled. Such news items cannot be said to prove themselves. Then, my lord, there are 20. It may be added that the Supreme Court indicated that they may be taken into account with further evidence if the other evidence is possible. But in the instant case, the sole evidence is the newspaper report and nothing else. We cannot take judicial notice of the facts stated in a news item being in the nature of hearsay secondary evidence unless proved by evidence eluended. A report in a newspaper is not one of the documents referred to in Section 78 of the Evidence Act by which an allegation of fact can be proved. The presumption of genuineness under Section 81 of the Evidence Act to a newspaper report cannot be treated as a proof of the facts reported therein. It is well settled that a statement of fact contained in a newspaper is merely hearsay and therefore inadmissible in evidence in the absence of the maker of the statement appearing in the court and deposing to have perceived the fact reported. Although it was a criminal case. Now I am coming to that part of the thing. The learned trial judges say that was a criminal case, therefore, my lord, so far evidentiary value of the newspaper item cannot be applied. That this division bench has clarified. Although it was a criminal case, but the underlying principle as regards the evidentiary value of a newspaper report, as laid down by the Supreme Court in these cases, applies with equal force to the case in hand. Now, this was a case, my lord, where the division bench has decided. It is a case of Public Service Commission. The failed candidate challenged that he ought to have got much higher marks. Now, they have come to know from the newspaper clipping that they ought to have got higher marks than what been given. So now in this case, my lord, this honorable court has said newspaper item cannot be accepted as having evidentiary value. So therefore, although it's a criminal case, the same analogy can be taken in the civil cases also. So finding of the learned trial court, as your lordship has seen, the case cited by in the trial court by our counsel my lord, that the referred 1988 decision to, in order to satisfy, to have the satisfaction of the court that the section 81 and 78 without any corroborating evidence cannot take place, and the learned judge ought not to have taken up that. So that part of the finding is totally wrong. Like, it is the divorce the decision of the appeals court. Now, my lord, this decision I can hand over to you also. And ultimately, your lordship will find that direction is to deposit 50% of the suit valuation. Now it's a governmental company, as your lordship has seen, the central government organization. We have 15 tea state in the state of Assam. Now we have denied in our written statement that we are not going to say, because we are having 15 tea state. Now supposing, my lord, we say, now we'll have to get an approval from the central government. Now these are not that easy thing as the state government or central government organization. You get an information from the newspaper that is going to be sold out. It's not that easy. Within a day or two it can be done. So entire finding, even, my lord, if I take your lordships to order 38, order 38, rule 1 and 5, it's a PCDM. Not your eyes.
Yes, it depends upon the satisfaction of the learned trial court.
My lord, exactly.
When the trial court derives satisfaction from the affidavit, petition and the affidavit filed by the respondent.
Yes, my lord, my submission is this. If I read order 38, my lord, your lordship can decide.
Affidavit to provision. They have filed.
My lord, first your lordship may see what they have stated. That will be the relevant part. At your lordship may see page 57, the miscellaneous application they filed. The your lordship may turn to page 64, paragraph 13 onwards. Has your lordship got me? Page 64.
Got it.
Paragraph 13, your lordship kindly see that the petitioner came to know from the news channel, namely the Sentinel and various e-news platforms, that the company, namely Andrew and Company Limited, has been suffering acute financial stress, and the company is going to sell all its tea estate. This is they has come to know from the news channel Sentinel. Then para 12, the petition. Oh, sorry, para 14. That the petitioner has reliably learned from the online post of the newspaper, namely the Assam Tribune, about the financial crisis the opposite party number 1, which is the parent company of the opposite party number 2. That on 28/8/2024, a news article was posted online on the reputed news, that is the Assam Tribune, which read that the Assam Tea Employees Provident Fund Organization has proposed the sale of tea gardens operated by Andrew and Company. The proposal was made due to several financial difficulties faced by central public sector undertaking, which manages 10 tea gardens in Assam. The proposal was in response to the letter of the Assam Chief Secretary Ravi Kota to the Union Ministry of Head Industries, detailing the financial stress faced by the central PSC. Further, the newspaper article clearly stated that the property owned by the parent company is on the verge of sale. That on 24/8/2024, the Chief Secretary of Assam, Government of Assam, wrote a letter to the Ministry of Heavy Industries and highlighted that the financial difficulties are impacting the tea gardens and approximately 8,000 workers and their families. The Chief Secretary's letter also mentioned that Andrew and Company Limited credit rating has downgraded, hindering its ability to secure loans, prompting suggestions for possible measures, including a soft refundable loan assets. Now, my lord, page 15, that is from the YouTube channel, they have come to know. Now, these are the only presumptory value it has. Now, in order to, my lord, the law is, the appeals court is saying, the newspaper item along with the corroborative evidence. Now, on the basis of the newspaper item, the satisfaction of the learned judge is not correct, because order 38, your lordship will find. Order 38, rule 1, my lord, your lordship kindly see, where defendant may be called upon to furnish security for appearance, where at any stage of a suit or other than a suit, of the nature referred to in section 16 clauses A to D, the court is satisfied. Well, this is important. The court is satisfied by affidavit or otherwise that the defendant with intent to delay the plaintiff or to avoid any process of the court or to obstruct or delay the execution of any decree that may be passed against him has absconded or left the local limits of the jurisdiction of the court, or is about to abscond or leave the local limits of the jurisdiction of the court, or has disposed of or removed from the local limits of the jurisdiction of the court his property or any part thereof, or that the defendant is about to leave India under circumstances affording reasonable probability that the plaintiff will or may there be obstructed or delayed in execution of any decree that may be passed against the defendant in the suit. Now, these satisfaction of the learned judge obviously is not there because they are not going to abscond or they are not going to sell. And then, my lord, your lordship, once again come to Rule 5, my lord, where defendant may be called upon to furnish security for production of property, where at any stage of a suit, the court is satisfied by affidavit or otherwise that the defendant with intent or obstruct to delay the execution of any decree is about to dispose of the whole or any part of his property, or is about to remove the whole or any part of his property from the local limits of the jurisdiction of the court may direct the defendant within the time to be fixed by it, either to furnish security in such a sum as may be specified. Now, your lordship, kindly say entire basis of the satisfaction of the learned judge is the newspaper report. Now, if the newspaper report ipso facto is not admissible in evidence without any corroborative evidence, whether the satisfaction derived by the learned trial judge can be said to be correct. That is the only question, my lord, your lordship is required to give the finding.
But is there any denial statement in
Yes,
the
yes.
newspaper
Exactly.
that you are not going to sell the tea garden?
Right. We have stated that.
Is it part of the record?
My lord, this is a part of the record. Your lordship may see, we have specifically stated in paragraph 12 actually. In paragraph 80, page 85, your lordship kindly see. Paragraph 12. Paragraph 12, my lord. That
Yes,
the
yes.
statement made in paragraph so and so of the petitioner speculative media reports. The NGUL and Company Limited is a Government of India enterprise controlled by the Ministry of Industries, Government of India. Even though suffering financial hardship due to general fall of Indian tea market, it is absolutely false that the company is going to sell all its tea estate as falsely asserted by the petitioner. Even newspapers did not speculate allegations. It is submitted that almost all the tea estate of the state are for some time facing with financial problem due to various unavailable market condition faced by the tea estate. The opposite party number one being a central government undertaking, the responsible government officers have intercommunicated among various wings of the state and central government for progressive effort to rescue the tea industry, which does not mean that the entire tea estate under management of the central government will be sold out. Since newspaper items are speculative expression of opinion and above all are hearsay, the media reports are not true and presently all the tea gardens owned by the opposite party number one operating, functioning, managing and running as a going concern. The media reports, which one you say? Is 86. Then, my lord, the statement made in paragraph 17 of the petition has been false, unrealistic on the face of the record, and as such denied by the answering opposite party. Though it is not admitted that the opposite party number 2 is going to be sold out, it is submitted here that the petition number 2, a plantation industry having plantation of tea bushes, shade trees, factories, office, bungalows, quarters, and various other installation on an area of 3,000 acres of land, are all immobile properties, cannot be removed from its present location under any circumstances. The petitioner has deliberately made a false statement which cannot be made true simply because the statement is supported by an affidavit. The statement made in paragraph so and so false is submitted here that direction under Order 38 Rule 5 of CPC can be issued by the court on clear findings that a defendant with intent to obstruct or delay the execution of any decree that will be passed against the defendant when he is about to dispose of the whole or any part of the property, or is about to remove the whole or any part of the property from the jurisdiction of the court. Since the claim of the petitioner in the suit itself is disputed one, and since there is no proposal of disposing the T state being the opposite party number two, the opposite party number two being a plantation spreading over 3,000 acres of its land, which is valued about not less than 100 crores, is entirely immobile property and cannot be removed or shifted out of the jurisdiction of this honorable court. Now, on the face of all these things, my lord, your lordship has seen the basis of, my lord, what they are saying that we are going to sell it is the newspaper report. Now, when the newspaper report is not admissible in evidence, without taking any further evidence on the matter, the finding cannot be given on the basis of the newspaper report only. My lord, I have some other decision also I would like to highlight before the lordships. I'll take your lordship to a decision of Apex Court. Two 2008 2 SCC, page 302. Lord, I'll refer paragraph 4, 5, and 6. Paragraph 4, the object of supplemental proceeding, application for arrest or attachment before judgment, grant of temporary injunction and appointment of receiver is to prevent the ends of justice being defeated. The object of Order 38 Rule 5 CPC in particular is to prevent any defendant from defeating the realization of the decree that may ultimately be passed in favor of the plaintiff, either by attempting to dispose of or remove from the jurisdiction of the court his movables. The scheme of Order 38 and the use of the words to obstruct or delay the execution of any decree that may be passed against him in Rule 5 make it clear that before exercising the power under the said rule, the court should be satisfied that there is a reasonable chance of a decree being passed in the suit against the defendant. This would mean that the court should be satisfied that the plaintiff has a prima facie case if the averment in the plaint and the documents produced in support of it do not satisfy the court about the existence of a prima facie case. The court will not go to the next stage of examining whether the interest of the plaintiff should be protected by exercising power under Order 38, Rule 5. It is well settled that merely having a just or valid claim for a prima facie case will not entitle the plaintiff to an order of attachment before the judgment, unless, this is important, Mani, unless he also establishes that the defendant is attempting to remove or dispose of his assets with the intention of defeating the decree that may be passed. Equally well settled is the position that even where the defendant is removing or disposing of his assets, an attachment before judgment will not be issued if the plaintiff is not able to satisfy that he has a prima facie case. The power under Order 38 Rule 5 CPC is a drastic and extraordinary power. Such power should not be exercised mechanically or merely on the asking. It should be used sparingly and strictly in accordance with the rule. The purpose of Order 38 Rule 5 is not to convert an unsecured debt into a secured debt. Any attempt by a plaintiff to utilize the provisions of Order 38 Rule 5 as a leverage for coercing the defendant to settle the suit claim should be discouraged. Instances are not wanting where bloated and doubtful claims are realized by unscrupulous plaintiff by obtaining orders of attachment before judgment and forcing the defendants for out-of-court settlements under threat of attachment. A defendant is not debarred from dealing with the property merely because a suit is filed or about to be filed against him. Shifting of business from one premises to another premises or removal of machinery to another premises by itself is not a ground for granting attachment before judgment. A plaintiff should show prima facie that his claim is bona fide and valid, and also satisfy the court that the defendant is about to remove or dispose of the whole or part of his property with the intention of obstructing or delaying the execution of any decree that may be passed against him. before power is exercised under Order 38 Rule 5. Court should also keep in view the principle relating to grant of attachment before judgment. Now, this is all about Order 38 Rule 5, my lord. Then another decision, my lord, in division
Not
bench.
necessary principle is same.
Pardon?
Not necessary to multiply the decision.
Yes,
Principle is same.
principle is same.
Anyway, I will go through the decision of this court referred by you.
My lord.
We will pass the order.
Another decision, my lord, I am just citing your lordship may see it. That is 88 Supreme Court, my lord. I read just para 25 and 26. My lord.
Okay. I will say.
My lord, just few lines, my lord, for my satisfaction. Para 25, your lordship will find at page 346. I'll not read the whole para. My lord, the line from 10, my lord, I will read. We cannot take judicial notice of the facts stated in a news item, being in the nature of hearsay secondary evidence, unless proved by evidence evident. This is the, my lord, the law. The report in a newspaper is only hearsay evidence. A newspaper is not one of the documents referred to in section 78(2) of the Evidence Act, by which an allegation of fact can be proved. The presumption of genuineness attached under section 81 of the Evidence Act to a newspaper report cannot be treated as proof of the facts reported therein. Now 26, it is now well settled that a statement of fact contained in a newspaper is merely hearsay and therefore inadmissible in evidence in absence of the maker of the statement appearing in court and deposing to have perceived the facts reported. The accused should have therefore produced the persons in whose presence the seizure of the stolen. Now I'm skipping to that. Then the next page, the subpara after 3 lines, the newspaper item without any further proof. This is very important, my lord. The newspaper item without further proof of what had actually happened through witnesses is of no value. It is the best second-hand secondary evidence. It is well known that reporters collect information and pass it into the editor who edits the news item and then publishes it. In this process, the truth might get perverted or garbled. Such news items cannot be said to prove themselves, although they may be taken into account with other evidence if other evidence is possible. Now, this is the law, my lord. Well, another decision, your lordship may say, I am not reading. This is also by the single judge, my lord, Justice Manish Chaudhary in para 2930. All these decisions, the law has been, my lord, enumerated in the same. Para 2930, my lord, down there I have written it.
Okay.
Obliged.
Item number 5.
May I please, your lordship. Lordship, the petitioners are the plaintiffs, your lordship. The petitioners have filed a suit against the respondents, defendants, and after filing of the suit, they appeared and filed their written statement as well as their counterclaim. Thereafter, the petitioner has filed an application, your lordship. Kindly see page 64. Under order 26, rule 10A, read with section 151 of the CPC. The instant petition has been filed by defendant number 1, your lordship, herein respondent number 1, with a prayer that the thumb impression of the defendant number 2, thumb impression of the defendant number 2 in the sale deed, which is the subject of the, which is the suit, your lordship, is sale deed dated 15/3 to 1995 may be verified by the forensic lab. that was allowed, your lordship. Thumb impression.
So what wrong with the order?
My ground, my humble submission before your lordship,
Hmm.
here in this suit, your lordship,
Hmm.
kindly see the page 13, your lordship.
Hmm.
Page 13, a cause title page, defendant number 2, Seniram Boro.
Hmm.
His thumb impression was sought to be verified.
Hmm.
But the said petition was not filed by the Seniram Boro. It was filed only by defendant number 1.
Seniram Boro already suffered demise. So where is the
Later on, lordship, after filing of the petition, the application was filed, your lordship, 6/6/2023.
Hmm.
And he died 10/9/2023.
Hmm.
That is one ground. And lordship, now the other ground is kindly see now impugned order page 71, your lordship, last part.
Hmm.
Hence, the defendant number 1 petitioner is directed to produce any original documents having thumb impression of deceased defendant number 2, Aadhaar card, etc., where a valid thumb impression of defendant number 2 is available. Before this court on next date as fixed in the main title suit number 46 of 2023, and the same will be sent to FSL Guwahati for verification by a forensic expert to compare the thumb impression of defendant number 2. That part, your lordship, while he was living, the petitioner was not filed by that particular defendant number 2 who executed the sale deed. This is one ground, lordship. And another, lordship, now during pendency after filing of that application, the defendant number 2 died. Earlier, the petitioners herein did not raise any objection, your lordship. Here it is there in the order itself, lordship. Page 68, your lordship. Last paragraph, page 68 of order. Objecting the prayer of the petitioner, the opposite party plaintiffs submitted that the plaintiffs have no objection in taking the opinion of handwriting fingerprint expert in ascertaining the thumb impression put on the registered unregistered sale deed which was executed on 15/3/1995. At that time, the petitioners did not raise any objection because he was alive and thumb impression could be taken from the defendant number 2, your lordship. And now, lordship, he is not alive. That is the difficult, your lordship, where to collect the thumb impression. So I am aggrieved.
No, thumb impression already existed on some other documents.
Some other documents, lordship, here it is specified that Aadhaar card, etc. It is specifically mentioned that part, lordship.
The last part of the order shows that the defendant number 1 petitioner is directed to produce any original documents having thumb impression of deceased defendant number 2, Aadhaar card, etc., where a valid thumb impression of defendant number 2 is available.
Now, lordship, defendant number 2, defendant number may submit a document saying that that is the original, having original thumb impression, that document. But
No, those documents will be produced before the trial court. Then you will be there to see the same, whether it is original or not. They will not send it behind your back.
after verification of that part, your lordship, that may be clarified, lordship. That may be clarified.
Pardon?
That may be clarified, lordship. After verifying that that is the original document,
No,
there
court will definitely verify it.
otherwise the petitioners do not have any objection.
Definitely pass an order to that effect.
Only because,
You
lordship,
will remain present there.
only because lordship, that defendant number two died, there arose some suspicion, lordship, that
No,
defendant,
maybe
other
there
defendant may.
is a thumb impression may be available in some other document. And whether those documents would be genuine or
That part has to be
there
looked into,
look
lordship.
after to verify the same. And the trial court will definitely verify the same.
Lordship, here in the order, it is observed that having thumb impression of deceased defendant number two before the court on next date on email. And now I have doubt that the defendant number is because he has filed an application. The defendant number two did not file any application. Lordship, kindly see that part.
No, maybe. That document was perhaps executed by defendant number two.
Yes, that document was executed by defendant number two, but he did not file that application to verify his thumb impression, Lordship. There is some doubt.
This
It
petition
is-
appears to be, Mr. Sum, this petition appears to be premature.
Lordship. If
After you withdraw this petition, wait till next date, you see what happened there. And if you agree, you approach this court again, we will see then.
Lordship, if the defendant number two whose thumb impression was put to sought to be verified, if he filed that application, but from this application, Lordship, kindly see, this application has been filed by the only defendant number two, son of the defendant number one, son of the defendant number two, and that defendant number two appeared before the trial court and filed his written objection. But he did not file that application to send
Maybe,
Lordship. There are some
maybe
doubt, Lordship.
defendant number one had
Is
the
a son.
application. Where is the bar? What to do?
Lordship, if it is clarified that that original document would be verified by that part.
Trial court will definitely verify the same. Why direction is necessary? And you will see the document before the trial court? Withdraw this application.
I may be allowed to withdraw and liberty to file.
Liberty, yes.
Lordship.
Part, sir, so Lord Counsel for the petitioner. Mr. Some said he may be allowed to withdraw this application, granting liberty to him to oppose his court again by filing appropriate petition. There is accordingly allowed. This civil revision petition instance dispose upon withdrawal. However, liberty will remain in the petitioner to address this court again by filing appropriate petition.
Item number
Oblige,
six.
your Lordship.
May I please, Your Lordship? Lordship, the petitioner filed a title suit and for declaration it changed deed number Iman as fraudulent, void, imperative and irrevocable recovery of possession against the respondent. And in that case, the petitioner filed a petition under section 60 of the BSA for secondary evidence. The petitioner filed some certified copy of registered sale deed number by agreement of sale and copy of will and exchange deed. And one copy is then photostat copy is the death certificate of one person's who is the another custody of the another person's. But the respondent filed objection and they in their objection, this is exhibit 1 to 6 are the photocopies, and court also presumed that all the photocopies. Hence, we are rejected our petition as order 60, section 60 of the ABSA. In impound order pages 18. In our petition in page number 11, it was mentioned that the plaintiff petitioner also submitted an exhibit 4 in form of the Xerox copy, which is copies from the original one. The original one in the custody of the third person who is not a party in the suit and refused to give the original certificate. As such, the original certificate is impossible to file in the court. But the Honorable Court presumed that all the photocopies is presented in the respondents were another people sent. In page number 20, it appears that the plaintiff petitioner, para 2, is seeking that the adduce secondary evidence is regard to some documents exhibited to prove her claim. According to the plaintiff petitioner, said documents in the custody of the third party. Only one document in the third party, otherwise on the certified copy. But the Honorable Court rejected our petition. It did not allow us to secondary evidence against the certified copy.
That what is this, the proceeding is pending now?
Pardon.
That what is this, the proceeding is pending now?
On the evidence test. And court has allowed to the petitioner sale text test procedure of the order 14 rule 6. Only for the death certificate. But what are we doing about these certified copies?
So what wrong with this order?
Yes, without proving the certificate copy says that this was through the secondary evidence that the petitioners be present from this, they did not get the relief from this original suit. Because the certificate copy is obtained from the registration office. Without proving this, that this copy is certified or not. Without proving this, we do not get a relief. In page 21, there is already discussed that when the original is a document in which certified copy is permitted by the pseudonym or by any other law in force of India to given in the evidence. It is in page number 21 of this judgment. Order. Actually, court presumed that all the documents are the photostat copy, but not all the photostat copy. Only death certificate exhibit 4 is the photostat copy, but 1 to 5 is the certified copy. 1 to 3 certified copy, or the other 5 and 6 are the original.
No, the trial court has observed that you have to satisfy the condition stated in section 60A of PSA 2023 to procure its benefit. You have not cited any specific reason besides that.
Already section 60 already permitted us to secondary evidence cases is a secondary evidence learning to documents. In F, subsection F, when the original is document of which the certificate copy is permitted by the adjournment or by any other law in front of India.
Respect of that death certificate, then
A death certificate, or for regarding the death certificate, we'll take step on order 14, rule 6, but the certificate copy will be necessary to prove. This death certificate is in only third party. But this one was the official documents.
Okay, madam, let notice go at this instance. Third means MD 19 learned counsel for the petition. Order dated 21/5/2025, passing title suit number 93 of 2022, is impugned in this petition under Article 227 of the Constitution of India, related section 105/151 of the Code of Civil. It is to be noted here that I impugn order dated so the learned trial court has dismissed the petition filed by the petitioner. Being petition number 1686 of 2024 under section 60 of Bharatiya Saksha Adhiniyam, related section 151 of the CPC. Let notice be issued to the respondent returnable in 4 weeks. The be taken by registered post with AD and also by usual process.
To state of further proceedings.
Since the proceeding is pending at the stage of evidence, further proceeding stands still returnable with December 4 weeks.
Highly obligations.
Item number 7.
May I please?
Yes.
The plaintiffs, and the plaintiffs, we have filed a petition under Order 6, Rule 17 for amendment of the plaint, Your Lordship. That has been rejected. And the rejection order is SP at page 41.
So
The
the
relevant
petition
portion
was
is-
for implement of Royal Academy.
Yes.
Whether you have claimed any relief against that
Yes,
academy?
yes, Your Lordship.
Hmm.
We have claimed that the para 4 of this plaint that has been stated here.
Para 4 of the petition.
Of the petition. Page 18. That the joint patta holder of their purchased land mentioned above, plaintiff and the defendant made an oral agreement to run the Royal Academy over the joint landed property. Accordingly, the plaintiff and defendant jointly applied before the Bilasipara Municipal Board, Bilasipara, on 12 to 2000 to obtain permission construction of building. Accordingly, the Bilasipara Municipal Board, Bilasipara, NOC to construct G+2 provision RCC building on in the name of the plaintiffs and the defendant over the said landed property. As a result, the plaintiff and the defendant jointly constructed G+2 provision of the building and the said joint landed property, paying equally share of the amount of the oral agreement to the plaintiff's share out of profit,
No,
running the said, the Royal Academy School.
Mr. Upadhyay, you see, this academy was established by both the parties.
Third
By a
party.
deed of trust.
Deed of trust
Right.
by third party.
Yes.
The land belongs to the plaintiffs and defendant. And they have constructed a building and they have given the Royal Academy to run the schools. And if there is any income, then they will share the profits. So that is the in between these three parties. So, but inadvertently, they have not implemented the Royal Academy.
No, that's all right, but in your petition, have you stated that the relief you have claimed against that institution? Where is your petition?
Yes, your lordship, page 35.
Page 35. Yes, what relief you have claimed against that institution?
The Royal Academy cannot claim the ownership of the land and building, and no such registered deed has been executed in favor of the Royal Academy. The Royal Academy does not receive any grant from the government.
In which paragraph you have stated it?
It is page 36.
Yes. Paragraph number.
Paragraph number 3. Then that has to be added. The Royal Academy cannot claim ownership of the land and building, as to such registered deed has been executed in favor of the Royal Academy. The Royal Academy does not receive any grant from the government, and 3, 4, 5 as well as according to the facts of the oral agreement. 3, 4, 5 means Royal Academy, made in between the plaintiff and the defendant 1 and 2, but in spite of the knowing facts, they in collusion with the defendant number 1 and 2 are not paying the 25% profit as agreed. That is against the Royal Academy. The defendant number 1 to 5 are jointly liable for payment of the profit of 25%. Next paragraph, page 37. So it is mentioned here. And the Royal Academy is a necessary party, and at any time it can be impleaded as a party, as per Order 1, Rule 10.2.
No, the question is what relief you were claiming against that party, and whether any effective decree or order can be passed without that party or not.
Basically, relief
You
sought
have to
is against
satisfy
the
the
defendant number 1 and 2. The declaration of right title interest and recovery of cost possession suit led by evicting the defendants. So defendants include all. Directing the defendants to give the plaintiff details. The lordship may hurt the other parties.
and who will represent that academy?
Represented by that is
By you or the other party?
Yes.
You or the other party?
Represented by the principal, chairman, these 3 persons, your lordship. It is there, your lordship, with the petition. Page 37. Bilasibal represented by its president, secretary, and principal. All 3 persons were are liable to be impleaded in this case. So we have asked for that. We have prayed for that, the impleading these 3 parties.
Okay, let notice flow at this instance. Third, Mr. N.N. Upadhyay, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, related Section 115 and 151 of the Code of Civil Procedure, the petitioner has challenged the order dated 21st of June 2025, passed by the learned civil judge, Junior Division, Bilasipara, in Mijay case number 165 of 2024, arising out of titles of number 749 of 2024. So we have noted here that by the given order dated so the learned trial court has dismissed the petition filed by the petitioner under Order 6 Rule 17 reduced Section 151 of the Code of Civil Procedure for amendment of the plaint by making new addition in the plaint. Further the petition and the documents placed on record, and also further the impugned order dated 21/6/2025. Let notice be issued to the respondent returnable in 4 weeks that be taken by registered post with AD and also by usual process. We can wait from today. List after 4 weeks.
The further proceeding may be stayed. It is my plaint.
And taking note of the submission of Mr. Upadhyay, learned counsel for the petitioner, and also considering the given facts and circumstances of the record, further proceeding of the title suit number 49 of 2024 stands stayed till returnable date. List after 4 weeks.
Obliged.
So item number 8.
Madam, here whatever madam, just check history. A suit was filed by the president of the party as plaintiffs against us in 1997, madam. Claiming a portion of land in the midst of 6 biga, 2 katta 5 lesas in my lord Dumani Soki, near Sibadar. Whatever matter, the 4 katta land was in the midst of the and my lord, there was a claim in the plaint.
When the title suit number 16 of 1997 was decreed?
It was decreed, my lord, on 36 2000.
2000.
Yes.
And you have filed a suit in the year 2024.
Yes. No,
thereafter. What you did for
no, thereafter we will file 47 application.
Thereafter?
47 application.
Thereafter what happened?
Then that was dismissed. We came to High Court. Then in the meantime, instruction came that we should withdraw the case and move the.
Mr. Sharma, recently Supreme Court has directed the High Court.
Yes.
Issue one circular.
Yes.
Directing the executing court to execute the decree within 6 months.
See, within 6 months.
Yes.
But matter.
Here the decree was passed in the year 2000.
Yes.
24 years.
That is true, matter. Just let me submit. What matter? Supreme Court, Honorable Supreme Court is, with all respect, has passed that order, matter.
No, Mr. Sharma, you cannot submit that in that way. You
No, no.
go and file a review petition there.
Where?
Supreme Court.
No. I am not party, matter. My review will not lie. That is different. Just one thing, matter. Let me just be kind, bear with him. What am I? After all, CPC. It took many years to draft it. And there are provisions, my lordship knows, under Order 21, Rule 29, Order 21, Rule 97, 98, 99, 100, 101, and also under Section 47. So those are to be complied. Unless those are amended and set aside by the Parliament. With all respect and humble submission, matter, perhaps Supreme Court.
No, maybe. But that is the law.
No.
As on today.
Here, my lord,
We
now I am coming to
we are
fact.
bound to follow
No,
it.
just a minute.
We are bound to follow
I
it.
am coming to fact. Decree has been, they have gone to execute the decree, matter, but there was some tussle and the proper land was not identified. So they left the matter. Just they put the one, red flag on the land and went away. Naziri and the party. And it is lying as that. Now, in the meantime, my lord, we filed an application under Order 21, Rule 29. And on the ground that a suit has been filed, being titled suit number 43 of 2024, along with the injunction pending in the court of the learned trial court, Mangalday. On that count, a temporary order of stay was sought under Order 21, Rule 29, which is provided under CPC matter. Yeah. The primary ground of the condition signed upon none was matter that there must be a suit pending in any court. So, matter,
You'll also kindly come to Order 21, Rule 29. Where suit is pending in any court against the holder of a decree
Rule?
Rule 29, Order 21, Rule 29. The absurd decree has been executed. It is not fully executed, but anyway, status quo is there.
Yes.
Where a suit is pending in any court against the holder of a decree of such court, or of a decree which is being executed by such court, on the part of the person against whom the decree was passed, the court may, on such terms as to security or otherwise, as it thinks fit, may stay execution of a decree until the pending suit has been decided. This is there. So I've exercised this.
No, the word may is there. Court may grant it, may not grant it.
Yes, may also mean shall, my lord. So now my humble praise, my lord.
No, here in this,
May-
it cannot be treated as sale.
No, the court may, on such terms to security or otherwise, as it thinks fit, stay execution of the decree until the pending suit has been decided. Provided that if there is the decree is one of payment, there is not applicable. It is a landed property. So, my lord, I have exercised this. So, suit is pending. Injunction petition pending. That's for hearing. Regarding called. So, for a short period, there was nothing. At least status quo ought to have been given. Let the land. Now, in fact, nobody is in possession. Decree, the bailiff came to execute the decree. There was some dispute regarding the identification of land. And he put the red flag mark and went away. It is lying like that. The notice may go, this is my lord. And
but there shall not be any stay. All right, we will stop.
No, status quo will also maintain. If they are in possession, let them in possession. I have no objection.
Let notice go at this success. Third Mr. Arpisona, learned senior counsel, assisted by
Edeka.
learned
Conjugal.
petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 27/3/2025, passed by the learned executing court in title execution case number 8 of 2018, whereby the learned civil judge Junior Division Monoldo has rejected the application filed by the petitioner under Order 21 Rule 29 of the Code of Civil Procedure. During the pendency of the title suit number 43 of 2024, arising out of title suit number 16 of 1997. Peruse the petition and the documents placed in record, and also peruse the impugned order dated 27/3/2025. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by the state courts with AD and also by usual process within a week. List after 4 weeks.
Status quo may be maintained. Status quo. Status quo.
Item number 10.
All right, madam. Notice will issue notice by.
Yes, by both the way. Registered post with AD and also by usual process.
By usual process.
May I please your lordship?
Yes.
This case is a very long history, my lord. The one Mr. Kishorilal Bagaria. One Mr. Kishorilal Bagaria was the owner of 1 kata 9 acres of land. He is governed by the Mitaxara School of Law. He had 2 sons and 4 daughters. During his lifetime, he gifted the land, 1 Katha 9 Lesa, to Gopal Bagaria, one of his sons. When the other heirs came to know about the gift deed, they have challenged that under the Mitaxara School of Hindu Law, he cannot gifted the entire property of the land. Therefore, the suit was initially dismissed. On appeal, it was decreed, and in the High Court, decree was upheld. That means the gift deed gifted to Gopal Bagaria was set aside. And our prayer for perfect partition was granted. While the perfect partition was granted, the present petitioners, they filed a petition before the court that as the original plaintiff has not taken any step for the execution of the perfect partition, therefore they may be allowed to take step for the perfect partition of the property. That process was going on. In that process, when the respondent hearing, they filed an application that they have purchased the land of 1 Katha 9 Lesa from Gopal Bagaria, and they prayed before the court that they may be allowed to implead in the suit and may be allowed to file written statement. The trial court granted them to implead them in the execution proceeding, but their prayer for written statement was not granted. Against that matter, the present petitioner moved the Honorable Court. This Honorable Court held that they can take a part in the execution proceeding, but they cannot file written statement. But after that, my lord, they filed a petition after disposal of the case in the High Court, they filed a petition before the executing court, allowing him to file the written statement. That prayer was allowed. My grievance before your lordship is this. If a third party is allowed to file a written statement in the suit, already decreed, how a third party can file a written statement in the decreed suit? The decree must be first set aside, then the other party can file a written statement.
The decree has not been set aside.
Decree has not been set aside. When the decree has not been set aside, how did learned trial court pass an order? The present respondents can be allowed to file a written statement. That means this is a de novo trial. It will start from the beginning, from the written statement, issues, document, which has already been decided, upheld by the High Court. Therefore, the impugned order passed by the trial court is directing them to file a written statement is bad in law, and that is liable to be set aside. Impugned order is at page 107.
No, you see the observation that accordingly there is no doubt, the trial court has observed that accordingly there is no doubt that the present petitioner is contesting the main suit, and therefore the petitioner has a legitimate right to place their case by filing written statement.
Yes. How the written statement they can file? What their legitimate right? They must first set aside the decree, then they can file a written statement. This observation of the executing trial court is wrong. Accordingly, there is no that the present petitioner they contesting the main suit. They are not contesting the main suit. They filed a petition to implead.
In execution proceeding.
Yes. When we filed a petition to make a preparation of the decree, of the preliminary decree for partition, then they filed a petition. The learned trial court allowed to implead them, but their prayer for filing written statement was rejected. After disposal of the written in the case before the High Court, they filed again a petition to file written statement. And the learned trial court allowed them to file written statement. How did
But perusal of the order.
perusal of the
Order indicates that it was filed in the title suit number 426 of 2010.
preliminary, my lord, the preliminary decree is to be executed. In the main suit, in the main suit they have filed. How their prayer for main suit can be allowed when the preliminary decree for preliminary decree has already been passed. Page number 102, your lordship, see.
Last line.
Last line. Last line, be that as it may, it is observed to the effect that the preliminary decree, unless challenged in the appropriate proceeding,
Page number?
Page number 102, 102.
102.
On the last line, at the bottom. Be that as it may, it is observed that the effect of preliminary decree, unless challenged in the appropriate proceeding, would continue to be binding upon all parties, suit, including those claiming under them. In the preliminary proceeding, the third party can file a petition, but not in the suit.
Okay, let notice go.
And my lord, the further proceeding of the suit may also be in state, because the trial court has allowed to file written statement.
Heard Mr. S.A. Sharma, learned senior counsel, assisted by Mr. G. Bhardas, learned counsel for the petitioner. The order dated 25/6/2025 passed by the learned civil judge junior division number 1 Doguri in Misje case number 32 of 2025, arising out of title suit number 426 of 2010. Is challenged in this petition under Article 227 of that section. It is to be noted here that by impugn order dated so and so, the learned trial court has allowed the respondent hearing.
Respondent number 1 and 2.
Respondent number 1 and 2 hearing this petition to file to place their case by filing written statement. Mr. Sharma's learned counsel for the petitioner submits that in the title suit number 426 of 2010, already one preliminary decree has been passed. And without setting aside the same, the learned trial court has allowed the respondent number 1 and 2 to file their written statement in the original title suit number 426 of 2010. And in that view of the matter, the impugn order dated so and so is illegal and arbitrary, and therefore Mr. Sharma contended to set it aside. The submission of Mr. Sharma needs further consideration. At this stage, a notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. And considering the fact that already one decree has been passed, preliminary decree has been passed, and without the same being set aside, the learned trial court has allowed the respondent number 1 and 2 to file their written statement in the original title suit number 426 of 2010. This court is inclined to stay the impugn order dated so and so till a returnable date. List after 4 weeks.
I'll read this. May I please, your lordship?
Yes.
My lord, this petition is arising out of an order rejecting my prayer for adducing secondary evidence. What happened is, this is a probate title suit. The original will was in the hand of the respondent. I have a copy of the will that was sent to me by one of my friend, and I have stated in my plaint that your lordship kindly see the page 15, paragraph number 4. That the that the original copy of the will was lost, and a copy could not be traced out in spite of vigorous search. The petitioner lodged FIR before the officer in charge on the month. The petitioner possesses a photocopy of the will, which was sent by to her by email by one Amarjyoti Medhi, who is one of the witness in the will, said will. The petitioner has annexed the said will, which has received by the petitioner in her email ID number so and so, and Amarjyoti Medhi through his email number so and so. There is no bar in accepting the photocopy reciting the probate case. This is my paragraph number 4 of the plaint regarding the will that I got the copy from the email manual. And in reply to the paragraph number 4 at page 24, that the entire statement in paragraph number 4 of the application is not correct.
Page number?
Page number 24.
Yes.
I have stated in my paragraph that I got the copy through email. The entire statement made in paragraph number 4 of the application are not correct and is vehemently denied by the opposite party. It is specifically denied that the original will was lost and the copy of which could not be traced out in spite of vigorous search. In this connection, the opposite party and the petitioner put to strict of this faith. The opposite party further stated the petitioner, in collusion with the witness, Amarjyoti Medhi, has manufactured the will and put the concocted story of the original will. Thereby, the petitioner has committed the forgery for sitting and the opposite party in collusion with her aid. Their reply is this, that the copy of the will I got is a manufactured. So far, therefore, I filed a petition. I also prayed for directing the respondent to produce the original will. Because we came to know that the will was in possession of the respondent. He has refused to produce that will. Therefore, we filed a petition for adducing this copy as a secondary evidence. And the learned trial court rejected my prayer, which is at paragraph number 8, page 50. That apart, the plaintiff has prayed to allow the accused to print out copy of the email received by her as the secondary evidence. Apparently, the original document is not available in the computer system. Secondary evidence includes the copy made from the original by way of mechanical process or copied compared with the original. In the present case, original itself is allegedly lost. It is clear that where the sender of the email obtained a copy of the will, the copies made from the original and the copy of the another copy cannot be used as a secondary evidence. What cannot be done directly cannot be done indirectly. And therefore, my petition for secondary evidence is rejected. It's asking this. So for the proof of secondary evidence, proof of a document by secondary evidence, the Supreme Court held that there must be a foundational fact in the plaint. And what one to produce by secondary evidence, that must be mentioned in the plaint. And that part was discussed in the case 2020 SCC. This is the judgment. Only requirement to prove a document by secondary evidence is the foundational fact. Whether the document is accepted or rejected in the trial of the suit, that is different. Paragraph number 11, your lordship can listen. 11 of the judgment. A perusal of section 65 makes it clear that the secondary evidence may be given with regard to the existence, condition, and contents of a document if the original is shown. It appears that to the possession and power and the document which sought to be produced or to be produced reach subject to the process, the court. And a person is bound to. The notice mentioned in section 66 does not produce it. It is settled principle of law that the secondary evidence is admitted. Foundational evidence has to be given by reason as to why the original evidence has not been furnished. There must be a foundational evidence. And therefore, I have stated, I have made a foundation in paragraph number 4 of my petition that I got the copy from the death. And it said, paragraph number 19 of the said judgment will also can receive. The appellant would be entitled to lead secondary evidence in respect of the will in question. It is, however, clarified that such admission of secondary evidence automatically does not attach to its authenticity, truthfulness, and the genuineness, which will have to be established during the course of the trial in accordance with the law. The will I want to produce, that does not mean that the will is proved. The petitioner has to prove the existence of the will by calling upon witnesses and other things are there. By reducing the secondary evidence, paragraph 19 is very clear. And the learned trial court has not considered this aspect of the matter. And moreover, my lord, PW3, I have examined one PW3 who was the attesting witness of the will. And he was cross-examined by the respondent.
Then why the trial court has rejected your plea?
Trial court has rejected on this WC.
What is the ground?
Ground paragraph number 8, page 50. That apart, plaintiff has prayed to allow her to produce the printout copy of the email received by her in the secondary evidence. Apparently, the original document is not available in the computer system. Secondary evidence includes the copies which made from the original by way of mechanical process or copies compared with the original. In the present case, the original itself is allegedly lost. It is not clear as to where from where the sender of the email had obtained the copy of the will, the copies of the will must be made from the original. A copy made from the another copy cannot be used as a secondary evidence. That is his ground.
No, is there any wrong in this observation?
This
A copy
observation,
made from another copy cannot be used as secondary evidence.
secondary evidence I can produce from the copy, from the computerized copy or the photostat copy. But that proof of the secondary evidence does not create any title as paragraph number 19 of the judgment says. It is only proof. And it is the duty of the petitioner to prove the said will. Otherwise, her case will go. If I am not allowed to prove my will, which I have received from email, then I have no case. And the learned trial court has misread and misinterpreted the section 65 and 66 of the Evidence Act. So far, secondary evidence is concerned. Secondary evidence is paragraph 19 of the judgment is here. It has stated, however, it is clarified that the admission of secondary evidence automatically does not attach to its authenticity, truthfulness, and genuineness. Therefore, the rejection is
No, you see, this observation of the trial court that a copy made from another copy cannot be used even as secondary evidence.
there is nowhere I found, my lord. I have gone through the various papers. A copy from the copy cannot be made as a secondary evidence where the learned trial court got this principle. I have not found. My lord, only point is, so far secondary evidence is concerned, there must be a foundational fact in the plaint. One cannot bring a secondary evidence which was not pleaded in the plaint. But in our case, we have very specifically stated that the original copy was not produced. Therefore, I want to produce this document, computerized copy I have received from one Amarjyoti Methi. If I am unable to prove this computerized copy in evidence, then the petitioner has no case. This point may be looked into, my lord.
Pardon?
This point is to looked into whether a copy from the copy can be made in the secondary evidence or not. But I have seen the evidence that there is no such thing is there. Computerized copy or a copy from the copy cannot be exhibited as secondary evidence. That part is not there in the Evidence Act.
As far as I know, there is one decision of the Supreme Court on that point. Secondary evidence. Okay, we'll reserve the order. Third, Mr. S.S. Sharma, learned senior counsel, assisted by Mr. J. Berta, learned counsel for the petitioner. Correctness or otherwise of the order dated 2/4/2025 passed by the learned. Additional district judge number 2, Kamrup M. Guwahati, is challenged in this petition under Article 227 of the Constitution of India. It is to be noted here that by the order dated so and so, the learned additional district judge number 2, Kamrup M. Metro Guwahati, in Miss Forbet case number 5 of 2017, has dismissed the petition filed dismiss the petition number 197 of 2024 filed by the petitioner under order 7 rule 14 3 of the CPC.
Order, no, order it is.
And also the petition number 196 of 24 filed under order 11. Order 11, Rule 14, related section 151 of the
My
CPC.
lord, I have only challenged the petition number 197,
197.
196. Other petition was allowed.
Okay.
My lord, your lordship may issue notice to see, let them appear and see what is their case.
And that's all right, but we'll see if we can dispose of the petition at this motion itself. We'll go through the decision referred by you and also the provision of law. Thereafter pass the order. (151) CPC and section 65 and 66 of the Evidence Act. Order reserved.
Items for reference to mediation. At number 12.
May it please your lordship. Your lordship, I think this matter cannot be referred to mediation. A law point is involved here.
Whether service completed or not?
Yes, your lordship. Respondent number 1, Mr. P. Sundi is appearing. And so far as respondent 2 and 3 is concerned, they have been struck off.
They?
Struck off.
Third, Mr. S. Dotto, learned counsel for the appellant, none appears for the respondent on call. Though the name of Mr. P. Sundri, learned counsel for the respondent number 1, is reflected in the cause title. The cause list. The case is listed before this court under the column for reference. Now, for referral to the special mediation drive test, mediation, put an inverted comma, for the nation. Mr. Dr. Learned Counsel for the petitioner, no, for the appellant submits that by referring this matter to the mediation, no purpose will be served, and as such, he pays for listing the matter for hearing. Record has been received?
Yes, your lordship. Series.
As the matter is also ready for hearing. Accordingly, it is provided that recess shall list the matter on February 6 at 18th matter, 3rd of September.
Much of it.
Item 30. May I please your lordship? Lordship, this matter cannot be referred to the mediations. Lordship, as per the office note dated 21/7/2025, according to the process server, respondent 1 is out of station and his family member refused to accept the notice. Lordship, fresh steps can be taken against respondent number 1. He is the claimant.
Mr. Mukherjee, you were for respondent number 2.
One being from Mr. KK. And for respondent number 2.
Respondent number. So notice upon respondent number 1 deemed to have been served.
Yes, Lordship.
So should we refer the matter to the mediation?
Lordship, respondent number 1 is the claimant in this matter. And we are the owner cum
So
driver.
who preferred the appeal?
Lordship, owner cum driver. Owner cum driver.
Owner cum driver.
Lordship,
Then respondent number 1 is the
claimant.
Award was to be paid by the owner. The award was to be paid by the owner from judges.
Acha, pay and recovery. Is there any
Directly by the owner.
directly by the owner? Okay. Then there is no chance.
Yes,
No
Lordship.
chance for compromise.
Payment was taken by the.
What is the compensation amount?
1,39,000.
Okay. Third, Mr. Your good name, please.
Yehu Ahmed,
You Ahmed, Learned Counsel, appearing on behalf of
K. Bhattacharya.
K. Bhattacharya, Learned Counsel for the appellant, and Mr. Mukherjee, Learned Counsel for the respondent number 2.
Mr. KK Bhatta. On behalf of Mr. KK Bhatta.
KK
Bhatta.
Bhatta. Mr. Mukherjee, Learned Counsel, appearing on behalf of Mr. KK Bhatta, Learned Counsel for the respondent number 2. Office note dated 21/7/2023 indicates that notice upon respondent number 2, respondent number 1 deemed to have been served. Deemed to have been served. The Learned Counsel for the appellant submits that no purpose will be served by referring the matter for mediation. And the matter is ready for hearing. And as such, it may be listed for hearing. There is accordingly allowed. This is at least the matter for hearing in usual course.
Number 14.
Wait, please, your lordship. Your lordship, this case is not fit for mediation, your lordship. We have denied our liability, your lordship. There was no policy on the date of accident, your lordship.
Now, this IA is for what purpose?
Lordship, appeal is yet to be admitted.
Appeal
your
has
lordship.
not been admitted
It
yet.
was not admitted. There was a direction for taking steps, your lordship. Accordingly, respondent number 1 to 3 has entered appearance. But as regards respondent number 4 and 5 services not completed, your lordship. They are necessary party here since we are denying our liability, your lordship.
So you have to take fresh step upon respondent number 4 and 5.
Yes, your lordship. We have to ascertain the address of respondent number 5, your lordship, since addressee could not be located as per office note dated 22/7/2025.
Third, Ms. P. Bartakur, Learned Counsel for the appellant, and Mr. Mandal for respondent number 1 to 3.
Yes, 1 to 3.
Respondent number 1 to 3. Office note dated 22/7/2025 indicates that card in respect of respondent number 4 has not yet been received back by the registry. And in respect of the respondent number 5, answer notice returned with postal remark addressing cannot be located. Cannot be located. Ms. Porter submits that she will take first step upon both the respondents.
Lordship.
Both the respondents. Accordingly, it is provided that step be taken by registered post with AD and also by the process within a week from today. Place the matter after 4 weeks.
Your Lordship, for admitting the appeal, presence of 4 and 5 is not required. Let the appeal be admitted.
No, appeal already admitted.
No, appeal has not been
It's
admitted.
not admitted, Your Lordship. It has
It has
for
to
admission, Your Lordship.
either come for admission or your Lordship, please, it can be admitted today also. Stay is.
It is submitted at the bar that though notice has been issued by the order dated 4/11/2024, the appeal has not yet been admitted. Then accordingly, it is submitted that the appeal may be admitted. But a record was called for.
Yes, Your Lordship, record was called for, but NCR has not been received, Your Lordship.
When the record was called for?
On the same date, Your Lordship. 4/11/2024.
No, madam, there is no order.
Office
No,
note, office note states that no NCR has been received, Your Lordship.
No, your Lordship, no,
Office note.
no order has been passed regarding LCR.
Accordingly, it is provided that registry shall call for the record from the learned tribunal. Place the matter after 4 weeks. Along with the IA number 334 of 2024.
Lordship.
Next that we will consider the IA.
Obliged.
Obliged.
May I please, Your Lordship? Lordship, conducting engaged counsel is like another course, Lordship. Or I'm paying for time being, Lordship.
Your Lordship, it may be taken after some time.
Taken up?
Taken after some time, your Lord.
Okay.
Obliged.
Items for admission, item 16, part heard matter.
May I have Lordship? Lordship, matter pertaining is a provincialized Lordship, rather than the LP school Lordship. So last question, Lordship. So my friend learned counsel Lordship submit some documents annexer 1, 2, and 3 Lordship, the scan copy Lordship. So Lordship, hearing the case is very simple, please, Lordship. So the school has provincialized in the year of 2013, Lordship. So thereafter, Lordship, so due to the non-dice, the school has withdrawn the provincialized Lordship. And
Subsequently, provincialization order was cancelled.
yes, Lordship. So Lordship, here in Lordship, the page number 37, so BO has clearly defined Lordship, the school record with effect from 2009 and 2010 is available, Lordship. Can you find page 37, Lordship, in my read picture?
Yes.
Mary, Lordship.
So we have called for the record from the office of the block elementary education officer.
Yes, Lordship.
That record has been received.
Received, Lordship.
And what does the record indicate?
This one?
Lordship, the record I don't think is received, I think. On the last occasion, I think Lordship had called for.
Lordship, the last order dated Lordship 9/6/2025, Lordship.
It has
So
not come,
herein-
I think, madam.
Herein Lordship directed to annexer 1, 2, and 3 Lordship from the Bolog Limited Department, Lordship. And that part has already submitted by my valid friend, Lordship. Record for question. So I have no
Record has
idea.
not been called, only the annexure 3.
So herein reflect Lordship, last order dated 9/6/2025. To enclosure 1, 2, and 3 of the letter of the block elementary education officer, casually dated 13/2/2024 before the Honorable Court on next day. This is the matter on 18/6/2025 as per our Lordship. So this is the reflecting order dated 9/6/2025, Lordship. and subsequently dated lordship,
Sir, I need some time to get the, today I have not received the thing, my lord. The enclosures which have been asked. The enclosures which have been asked has not been, my lord, given to me because the directorate has written to the block elementary education officer. Since it's, my lord, casually, my lord, some time may be given, my lord. You cannot obtain it.
No, on the other day, Mr. P.N. Sharma has produced some documents.
yes, lordship.
Whether those documents were the enclosure number 1 and 3 of the block elementary education officer Tekezuli of his letter dated 9/6/20. No,
Yes.
letter dated 13/20/2014.
Yes, lordship.
Lordship, in this matter, some time may be given, my lord. I'll get my, because on the last occasion I was not there, Mr. Sharma was there. Because today, I don't have the up-to-date instructions, sir. I'll have to, because one letter is there, my lord, which is been written from the director to the BEO, stating that to produce those annexures. So I think, my lord, some time may be given, my lord. At least a week's time or a little more, 10 days, my lord. I'll try to bring it, my lord.
Letter.
Yes, next week.
Heard Mr. Arcidas, learned counsel for the petitioner. And Mr. A. Fukun, learned standing counsel for the respondent in elementary education department. And Mr. Gogoi for respondent number.
Number 7.
7. Respondent number 7. Mr. Fukun submits that he may be granted some time to go through the annexer and go to the enclosure, it's number 1 and 3 of the letter of the block elementary education officer Tekezuli dated 13/2014. Where is accordingly allowed, list the matter on Ex-parte.
On 6th August.
6th of August.
Lordship, this is the final date, lordship. It is disposing the matter.
Mr. Pokon, you come prepared. The registration will reflect the name of Mr. Pokon
Madam.
in the cause list.
Item numbers 17 and 18.
May it please the lordship. Lordship, the petitioners have got the current salary, lordship. Thanks to your lordship intervention.
They have got the
And-
current salary, my lord. I have got my instruct that monthly salary in respect of petitioner of so and so, Shariful Islam, science teacher, has been released and paid to the incumbent, and the arrear proposal for the period from December 23 to February 25, as directed by the DE, has also been forwarded to the District Elementary Education Officer Dhubri. The BEO so and so has stated that application for creation of NPS in respect of Shariful, along with supporting documents, has been submitted to treasury office.
Lordship, it
And
has already been forwarded direct. Lordship, I have given.
So, my lord, it is in the right track, my lord. It is in the right track now.
So we cannot dispose of the matter today.
Yes, madam. Because last time your lordship had kept it today because just to monitor the situation, whether it is being if there will be any progress or not. So today, my lord, I have got instructions, my lord, that there is progress.
So Pokon, this is not legible copy.
And the first part of it, first part. Which I have taken out the printout from the court this thing only.
Wait.
I think the ink there is less, man.
Mail question.
Take that question.
For sure, I'll try.
So you have received the current salary.
Lordship.
He has received.
On 2nd of July.
2nd of July. And in respect of arrear salary,
Lordship, there is a proposal.
The proposal has been sent, man.
So when can it be listed again?
Lordship will have it after, my lord, 3 weeks, my lord, because my lord,
It
It takes some time. It will take some time, my lord. These things take time, my lord. Because if it again happens, well, again and again, we have to wait. If it doesn't happen on that day, again.
No, yeah.
So lordship
Now
will have
the
it
case
on.
will be pending for
3 weeks.
arrear salary.
But the other one is done. The lordship has on the last occasion said that clear his current term, so that has been done fully. And the proposal also has been made, my lord, and sent to the thing. And there was on the last occasion, there was an error regarding his place. That also has been corrected.
Name of the treasury.
Because of the treasury office delay, the money was given later.
Heard Mr. Islam, learned counsel for the petitioner.
He wants to argue, sir.
Miller, I am respondent number 7 and 8, Miller, in the item number 17, Miller. I have no any objection regarding part of the salary, Miller, but the main case is pending since long back, Miller. And the main case may be fixed for hearing any other day, Miller.
Main
Not
case is
yet,
for
admission. No. It is for admission. Let it remain for admission, lordship.
Because my lord,
main case is a writ petition.
Lordship, item number 17.
17.
Yes, my lord.
Lordship.
What happened in this case, my lord? A petitioner along with respondent number 7 and 8, government directed to provincialization, my lord, under Acts 2017, my lord.
The new.
A new rule, my lord. Under the 17 Act, my lord. A government issue order to provincialized petitioner along with the respondent number 7 and 8, my lord. But due to pendency of the writ petition, my lord, due to pendency of the writ petition, respondent number 7 and 8 are not getting any benefit. That's why, my lord, my humble prayer, my lord,
No,
in
there
case
is
may
no.
be fixed, my lord.
Is there any
Short
stay
date
order
even in the main case, my lord.
No. Is there any stay order operating?
Yes, lordship. A stay order regarding
There is
that impugn order.
Improvement. What happened in this case, my lord? Initially, his post is provincialized, my lord, but subsequently government cancellation his provincialization. And respondent number 7 and 8 post are provincialized, my lord. Against that order, my lord, petitioner approves this honorable court, and there is a stay order, my lord.
Let it be, my.
After 3 weeks.
It's already a stay.
There is a stay order. That's why, my lord, respondent number 7 and 8 not getting any benefit, my lord.
No, lordship. Is incorrect, lordship. Interim order passed to the effect that my service was directed to be provincialized under 2017 Act. That has been established, lordship. So my earlier service, provincialization of service under 2011 Act has been upheld, lordship. That is why your lordship has directed to pay me the salary, lordship.
Okay, next set we will
Lordship.
make an endeavor to dispose of the matter.
Short date may be given, my lord. Pleadings completed.
So let that matter come up with the main case.
Yes.
Because otherwise there will be confusion. Other case, the 3 weeks time may be given. In the meantime.
3 weeks in the contempt case.
Yes. So it is stacked together, I think. The contempt is stacked
Or
with the main case.
Mr. R is learned counsel for the petitioners and also heard Mr. A. learned standing counsel for the respondent in the department. Then Mr. A. M. Ahmed for respondent number
7 and 8.
7 and 8. Mr. Islam learned counsel for the petitioner. Apprise this court that the petitioner has already received the current salary on 2nd of July. 2nd of July 2025. Mr. Okon learned Standing Council for the Elementary Education Department also submits that the proposal for payment of arrear salary for the period from December 2023 to February 2025 has already been received and the same is under process. Then he prays for listing the matter after 3 weeks. On the other hand, Mr. A.M. Ahmed, Learned Counsel for the respondent number 7 submits that in view of the stay order operating in this case, the respondent number 6 and 7 has not been receiving any benefit. And under such circumstances, he contended that the matter may be fixed for hearing and final disposal of the petition. Accordingly, it is provided that this is a place the matter after 2 weeks. After 3 weeks. Later.
20 August 20.
For admission, Lordship.
Yes, for admission. For final disposal.
Item 19.
Oh, yes, for admission.
May it please your Lordship. In this case, Lordship, the petitioner filed an application order 9 rule 7 to set aside the ex-parte order and thereafter to take her written statement in the suit, Lordship. That was rejected against that this revision petition, Lordship. In this case, what happened, Lordship, the petitioner filed a title suit for eviction of some tenants, Lordship, from her inherited property, Lordship. And while that suit is pending, one of the tenant, Lordship, informed her that there is another suit pending against her, Lordship. Then on inquiry, she came to know that another title suit is pending, Lordship. She, Lordship, given an power of attorney in the name of her husband and 2 other persons. Those 2 other persons executed a deed of agreement along with a third party, and thereafter the third party filed a suit for specific performance of contract. And in that suit, she was made defendant number 1. Notice was served. Without serving the notice in her house, it was hanged, Lordship. And thereafter, process server was examined, and on the basis of that, Lordship, the suit proceeded ex parte. And thereafter, when she came to know, she filed an application. That application was rejected, but she was allowed to cross-examine the plaintiff's witnesses. Against this order, Lordship, I am before your Lordship. So first of all, Lordship, my petition, that order 9 rule 7 petition.
Page number?
Page number, Lordship, 65. Though I have executed a power of attorney in the name of 3 persons, later on I revoked that power of attorney. Annexure 11, page 65. That the suit was proceeded ex parte against the defendant number 1 and the knowledge of the defendant number 1 in respect of this suit arises on 7th September 2020 and for which the defendant number 1 today filed the written statement before this honorable court for the purpose of acceptance of the written statement in this suit as it is filed before this honorable court within the limitation from the date of knowledge, that is 7/9/2020, by vacating the ex parte order so that the defendant number 1 may not suffer irreparable loss and damages. In the interest of justice, it is most respectfully prayed that your honor may be pleased to vacate the ex parte order dated 8/11/18 against the defendant number 1 and accept the written statement submitted herewith so that the defendant number 1 may contest the suit. And there another application was filed, that is Annexure 12, page 68. A petition filed Srimati Mosumi Datta Chaudhary, Mosumi Science under Order 9, Rule 13, read with Section 151. But Lordship, I am
No, impugn order is concerning this petition.
In both the cases, Lordship, order was passed. Order 9, Rule 7, page 73, impugn order. Yes.
Dated 16 to 2023?
Yes. It starts from
And
page
the other
71.
petition,
Other petition was all numbered as Midge case number 99 oblique
no, no,
2020.
they were challenging both the order.
Yes, Lordship. But Lordship,
In a
order
separate
9
order or same order?
separate order, Lordship. And Lordship, order 9 rule 13 will not come here. That's because no decree was passed. Suit is still pending at the stage of argument, Lordship. So annexure 13, page 71, your Lordship kindly see.
Page number?
71.
Yes.
Order dated 16/2/2023, the defendant number 1, Moshumi Datta Chaudhary, filed a petition by petition number 20412 under order 9 rule 7 CPC read with section
Okay,
151.
okay, but not necessary to read out the entire order. Yes, so
May I read the relevant portion?
what is your objection?
My lord, your lordship kindly sees page number 46. This is the process server's report. Now here your lordship will kindly see the process server was examined. He has categorically stated that I beg to state that on 24/9/2018 at about 12 p.m. I went to the house of defendant number 1 as per the address mentioned in the summon and informed her about the summon and asked her repeatedly to receive the same by putting signature. In spite of that, she refused to receive the same, and therefore a copy of the summon was served by affixing on the wall of her house in presence of the witnesses mentioned in the summon. Now here, my lord, the process server has discharged his duties in terms of Order 5 Rule 70 when defendant refuses to receive the summon. Your lordship is aware of Order 5 Rule 70. Now, thereafter, the examination of the process server has been conducted by the learned court below as per the provisions of Order 5 Rule 19. Now, after all this, having waken up from deep slumber, they come up on an off date and they file their written statement, try to file their written statement, and they file their petition under Order 9 Rule 7, praying for setting aside the order of ex-parte. Now, as per Order 9 Rule 7, your lordship, the defendant has to come up and show good reasons for her previous absence. Now, she has not even made a whisper in her petition as to why she refused to accept the summon which was taken to her doorsteps and was sought to be served by the process server. There is no explanation in her petition or no reason cited.
Let us see the petition.
Well,
Page number?
the Order 9 Rule 7 petition, I think that petition is
Page 65, Lordship. Just I read out that petition, Lordship.
yes, page 65. Now, your lordship kindly says it's a 2-page petition where there is no mention about the exercise that was carried out by the process server in going to her doorstep to serve the summon, and she deliberately and after repeated request, this is the examination of the process server, she refused to accept it. Now, where is the scope, my lord? This will be abuse of the process of law if she is trying to get herself. And even then, the learned court below has been kind enough to allow her to examine the plaintiff witnesses. To that extent, she has been, and the suit is filed by me for specific performance of contract, where the property obviously is her property, inherited property, but then she had given a power of attorney to 3 other persons, including her own husband. Now, with them, there had been an agreement for sale, and pursuant to the agreement for sale, I paid the advanced amount and thereafter the full amount. And now I expect that that contract, that agreement needs to be respected, that contract needs to be honored. Now, for that, I filed the suit. And now she is now trying to get herself she was already arrayed as the defendant number 1, having missed the bus. Now she is now trying to invoke the provisions of Order 9 Rule 7. But unfortunately, procedurally, my lord, perhaps she has already missed the opportunity. Now it has to go beyond the procedure.
so far filing of written statement is concerned, earlier earlier summons were issued, that thereafter it was again reissued. Now, thereafter, it was sought to be served by the process server and she refused to accept it. Then on an off date, after the passing of the ex-parte order, she comes with a written statement and an application under Order 9, Rule 7, and an application under Order 9, Rule 13, which is otherwise not maintainable also. Order 9, Rule 13 is not maintainable because that will only be in case of an ex-parte decree. Nonetheless, that order that was passed in Order 9, Rule 13, that has been challenged in this revision petition. My learned colleague friend is now saying that she is perhaps not pressing on that. But nonetheless, insofar as Order 9, Rule 7 is concerned, the mandate is that good reasons has to be cited. Now, whether in this petition from page 65 to page 66, this 2-page petition, whether your lordship will find any good reason here, she has not even mentioned about the reason why she refused to accept the summons when she was repeatedly requested by the process server. And the process server's examination she has
In this
annexed.
case, lordship, what happened here? Lordship, kindly see the annexure 2, page 24, my power of attorney. That power of attorney was given when
No, you tell me whether any reason has been assigned in the application.
from
under
my date of, I
Order
had,
9, Rule 7.
lordship, in that petition, we have already stated that from my date of knowledge, lordship. Even if that for these technical lacuna, lordship, the defendant number one is the main defendant, she is the main defendant. In this,
Maybe you have refused to accept notice.
but lordship, I will show your lordship that how she was, her plot was, they are trying to sold out to a third party.
No, we are not concerned with the merit of the case.
Lordship is
We are
at
concerned with
227.
only the reason.
Yes.
Why you have refused to accept notice.
Lordship, in fact, lordship, no notice was served upon the petitioner, that I
No,
will,
why we disbelieve the statement of the process server?
from the records, I will show your lordship that how the process server has served the notice upon the petitioner, lordship.
Okay. Oh, we'll
And
resume
on
it.
merit also, that suit is not maintainable as because lordship.
No. Oh, we are not concerned of the merit of the case.
Lordship will find there are some fraudulent activities taking
Oh,
place.
we'll see after after. Who is appearing for bar council?
I'm appearing for this one.
You were. So on the other day, one junior counsel entered appearance on behalf of bar council, and she submits that there is no requirement in the bar council regulation regarding obtaining permission from the state government. But the same appears to be incorrect. There is this regulation.
The regulation, find on page 36, 36 of the writ petition. Perhaps the learned junior counsel was referring to clause number 6, which my lord would find at page 37. The last page, my lord.
36 and 37.
36.
Yes.
37, my lord, clause 6. May I read?
Yes.
Copies of the affiliation letter, bracket, if it is an affiliated institution from the university, comma, NOC from the relevant government, if it is a state-owned or funded institution, must be submitted with the application. Now, insofar as an affiliated institute is concerned, my lord, there has to be an affiliation letter from the university. So, if they fulfill all the requirements in the guidelines, we do not have any objection for the affiliation method. But these has to be followed, man. So essentially, my lord, it is the university, my lord, who has to.
That is regarding inspection manual.
Yes, my lord. That's appended to the writ petition, page
Yes,
36.
but there is another regulation, Bar Council of India Rules of Legal Education.
2008. Yes.
2008.
My lord is referring to clause, my lord. Clause.
16?
16?
6.
6, Roman 6. My lord, just give me a moment. My lord.
The affiliation.
Regarding NOC clear like as application of
When a university makes an application for evaluation,
university of the that I will not compare of NOC.
when a university makes an application for evaluation. My lords, insofar as what I've understood, this Rule 16 pertains to inspection, my lords, by the Bar Council. If I may read the provision, my lords, 16 ones. When a university receives an application for affiliation of a center or legal education to provide legal education by running professional degree program in law, under either or both the streams, the university may, before deciding whether it is fit case for seeking inspection from the Bar Council, shall ensure that. Now, this rule would apply only when an institution applies to the university. For
In the present case also,
yes,
the petitioner college has applied to the university.
university. Now, if the university deems fit, my lords, then in terms of clause 6, if prior permission of state government is necessary, a no objection certificate is obtained to apply for affiliation. Now, my lords, I'll take instructions if required, my lords, but the Bar Council does not have any role in it, my lords. It is the state government, it's the university which has to, if a prior permission of the state government is necessary, a no objection certificate is obtained to apply for the affiliation. They can ask for a no objection certificate.
Oh, university. In the present case also, university has asked them to produce the this no objection certificate from the state government.
Yes. Now, if they fulfill all the requirements, we do not have any problem in granting affiliation. But as per our, which is there, which my lords would find at page 36 and 37, that has to be complied with. That is complied with, we do not have any objection in granting affiliation. Now the list is between the university and the petitioner, my lords, not the Bar Council.
No, I was asking the question only because on the other day submits that there is no requirement for obtaining no objection certificate from the government, whereas the Bar Council regulation provides it.
No, that is not.
In case of the private institution, my lord, not only all the cases, if the institution is private, then a NOC is not required, my lord.
On the you please come to is 16.6.
Yes, my lord.
My apologies for that, ma'am. That's not correct, perhaps. The submission made by the council on the other day. Now,
If say 16.6.
Yes, my lord. It is, my lord, if the, my lord, prior permission of the state government is necessary, a no objection certificate is obtained to apply for the affiliation, my lord. But the Bar Council, my lord, it is saying that a no objection is not required in case of the private institution, my lord. So it is their regulation, on the basis of their regulation, I am submitting that as my institution is a private institution, so NOC is not required in case of mine. But the other, my lord, government affiliating support, my lord, fund is required, fund going for the assistance of the government to run the institution, then the NOC is required. But in case of the private institution, NOC is not required, my lord. The issue is only the entire issue is revolving only on issue, my lord, not on the affiliation. They are saying that unless and I obtain the NOC from the government, they will not get affiliation. But the thing is that as per the Bar Council regulation says, the if the institution is a private institution, NOC is not required, my lord.
No. Can we ignore this 6?
At the same Bar Council, my lord, this is, I already, my lord, annexed the document, my lord. Here, this is very clear. It is also very clear, my lord. If I annex here, my lord, this is page 36, my lord. It is very clear.
That is only guidelines, but this is a regulation.
The regulation is based on the, my lord, guideline is based on the regulation, my lord. So this is the guidelines issued by the State
So
Bar Council, my lord.
we have to read both the guidelines and the regulations
Together, yes, my lord. So, my lord, it is clear in the guidelines that in case of the which institution, my lord, the NOC is required. Earlier, it is saying that the NOC, but NOC is where it is necessary, where it is required, this is given in guidelines, my lord. In the case of the private institution, NOC is required, but in case, no, NOC is not required, but in case of the, my lord, institution where in future they can ask for any government assistance or in government also this affiliated
You
institution.
see, if the permission of the state government is required,
Yes,
a no objection certificate is obtained to apply for affiliation.
yes, my lord. But the affiliation, my lord, state government is not saying anything, my lord.
No, already state government
Only by
notification
the
is
OM, my
there,
lord.
memorandum.
OM, my lord. OM, whether, my lord, OM can be override to the regulation, my lord. They issued the OM and OM also that too, my lord. I also read in earlier occasion. They have stated, my lord, OM, what is the definition, what is the requirement of the necessity. My college is, my lord, only the professional institution. They are not defined the institution, the professional institution not come under that OM. And moreover, my lord, the UGC, the affiliation regulation is very clear, my lord. The which regulation they have to follow. The UGC, my lord, the regulation regarding the affiliation, I already relied. They are also specifically, they have stated, my lord, the statutory regulation body, that means what they are meaning of this by this regulation.
May submit.
So it is also very clear from the regulation 2.6, my lord. The statutory regulation body means a body or constituted by the central of the state government act for setting and the maintenance of the standard in the relevant area of the higher education, such as All India Council of Technical Education, then Medical Council of India, then the Dental Council of India, and also the National Council of Teachers Education, and last is the Bar Council of India. So I am relying on the Bar Council because the statutory body is the Bar Council. So they have to follow the whatever provision is implemented in this provision of the Bar Council, that to be followed. They cannot own by own, and this is my moreover, their statement also contradictory because they are one way they are saying that there is statutory body. If there is a statutory body, why they are banning on the government OM? Their own statutory body. If there any provision is there, this their statute, then I have nothing to say. But there is no such provision is there in statute. And moreover, my lord, they have to go by the affiliation regulation of the UGC. UGC regulation, it is very much clear.
In that case, if I may kindly pray, my lord, can the matter be taken up on Monday? I'll take instructions and I'll clarify on this one. I'll clarify.
Okay.
If it can be taken up on Monday. Very grateful.
Yes, Mr. Pupano, what do you want to say?
There are two components, two stages. One, before inspection, second, after inspection. This 16.6. The keyword is before, May I read, 16? Last 16.1, running, when a university receives an application for affiliation to a center of legal education to provide legal education by running professional degree program in law under either or both the streams, now important, the university may, before deciding whether it is a fit case for seeking inspection from the Bar Council of India, shall ensure that.
Yes.
It is before deciding.
Yes.
So, it is before the inspection process, After, the university recognizes, gives the NOC, then that inspection stage comes, Then this page 36 and 37 will come into play, So, before and after. So, before deciding, this prior permission of the state government as per 16.6 is necessary. No objection certificate is obtained to apply for affiliation. And it is in tune with the ordinance, Ordinance of the Guwahati University, 1997, regulation 7.3, May I read that part, Permission to establish a new college. The Executive Council, on receipt of necessary concurrence from the state government, shall accord permission to establish the proposed degree college and shall issue necessary directions to the sponsoring body to implement the following requirements under time-bound period. So, as per the ordinance of 1997 of Guwahati University, this NOC from government is required. And the 11 judges constitution bench, On the last item, I could not, refer this, judgment, the government role and as regards private unaided professional college. 11 judges bench TMA 5 foundation and others. I take your also straight to paragraph 54, 55 and 70.
Yes.
Paragraph 54. The right to establish an educational institution can be regulated, but such regulatory measures must in general be to ensure the maintenance of proper academic standards, atmosphere and infrastructure, including qualified staff, and the prevention of maladministration by those in charge of management. The fixing of a rigid fee structure, dictating the formation and composition of a governing body, compulsory nomination of teachers and staff for appointment or nominating students for admissions would be unacceptable restrictions. So, regarding infrastructure, academic standards, atmosphere, in this arena, the state government's control is accepted in this 11 judges constitution bench judgment. Now, para 55. In the middle portion, I have marked it, There can be no doubt in seeking affiliation or recognition, the board or the university or the affiliating or recognizing authority can lay down conditions consistent with a requirement to ensure the excellence of education. It can, for instance, indicate the quality of teachers by prescribing the minimum qualification that they must possess and the courses of study and curricula. It can, for the same reasons, also stipulate the existence of infrastructure sufficient for its growth as a prerequisite, but the essence of a private educational institution is the autonomy that the institution must have in its management and administration. There necessarily has to be a difference in the administration of private unaided institutions and the government-aided institutions, whereas in the latter case, the government will have greater say in the administration, including admissions and fixing of fees. In the case of private unaided institutions, maximum autonomy in the day-to-day administration has to be with the private unaided institutions. Bureaucratic or governmental interference in the administration of such an institution will undermine its independence. Now, para 70. It's regarding private unaided professional colleges like the Writ Petitioners College.
Paragraph number?
Paragraph 70. I have marked it last 6-7 lines. It will be sufficient to the role of government as well as the university regarding NOC or affiliation.
Yes.
A college or a professional educational institution has to get recognition from the university concerned, which normally requires certain conditions to be fulfilled before recognition. It has been held that conditions of affiliation or recognition, which pertain to the academic and educational character of the institution and ensure uniformity, efficiency, and excellence in educational courses are valid, and that they do not violate even the provisions of Article 30 of the Constitution. But conditions that are laid down for granting recognition should not be such as may lead to governmental control of the administration of the private educational institutions. So, regarding the constitution of governing body, in that respect, the government has no role to play. But regarding the infrastructure and other, regarding academic standard, the government as well as university concerned has vital role to play. In view of that, this 11 judges constitution bench judgment in 2002, to be read with Rule 16.6 as well as the Ordinance Clause 7.3, So NOC from government would be required before giving recognition to a new college, and thereafter, that inspection of the Bar Council of India will commence, as per page 36 and 37.
Okay. Okay, we'll list the matter on Monday. In the meantime, you obtain inspection.
My lord, regarding this, my lord, this judgment, my lord, I am not opposing them. But before that, they have to comply their provision, my lord. Where is the inspection? They did not conducted any inspection before going to the decision, my lord. If it is not inspection is done, then how they can come to the decision that my infrastructure is not there? For that purpose, they want to see this. They have to say, my lord, first thing, they go for inspection. If it is not inspection is done, how they can come say that my institution is not following all the guidelines and other things, my lord. NOC will come a different thing. And regarding the NOC, my lord, their own, my lord, the statute, they were saying they are trying to insist that the NOC with the help of the OM. OM that cannot be, my lord, override to the statute, my lord. My humble submission on that.
Most of them.
Heard Mr. Mohanto, learned counsel for the petitioner, Mr. P.J. Popon, learned counsel for the respondent. Part 2, and you for P. Mohanto, learned.
Both are P. Mohanto, my lord.
learned counsel. For Bar Council of India. And for respondent number 4, and Mr. Somwa for in UCC, respondent number 3. Respondent number 3, and Mr. Bhuya for Higher Education Department.
My lord,
Listen,
one prayer, my lord. Instead of Monday, my lord, Monday, my lord, I am, my lord, badly occupied. So that may be on instead of Wednesday, my lord.
Wednesday.
Yes, my lord.
Wednesday? Okay. List the matter on Wednesday for further consideration at 2 p.m.
Mass of this.
Item number 19 to continue.
Yes, you come to the report of the process server.
Yes, Lord.
Is it part of the record?
Yes,
Yes,
the
Lord.
record.
Page number
46.
46, Lordship.
Page 46.
Type copy 46, vernacular 47, Lordship. I beg to state that on 24/9/18 at about 12 p.m. went to the house of the defendant number 1 as per the address mentioned in the summon and informed her about the summon and asked her repeatedly to receive the same by putting signature. In spite of that, she refused to receive the same, and therefore a copy of the summon was served by affixing on the wall of her house in presence of the witnesses mentioned in the summon. So this is the report, and later on he was cross-examined, Lordship. Before that, your Lordship, kindly see page 4, paragraph 2, Lordship. What is the facts behind the case, Lordship? The petitioner's father, Ashim Kumar Datta Roy, was the absolute owner of the land measuring so-and-so, covered by so-and-so, within the district of Kachar Police Station and Sub-Registry Office, Silchar, Pargana, so-and-so. On the death of her parents, she, being the only legal heir, inherited the aforesaid property. The petitioner filed title suit number 107 of 2003, which was renumbered as title suit number 633 of 2006 against the tenants who are residing over her inherited property for eviction on the defaulter ground. The said suit is pending before the Munsif number 1, Kachar, Silchar. So over the same plot of land, Lordship, another suit is pending. Now, paragraph 3, that the petitioner, due to her personal difficulties to manage the aforesaid property, executed one registered power of attorney being number 92/22 2014 in favor of her husband Bikramjit Datta, Sri Panna Das, Subudh Das. So against 3 persons, Lordship. Now, this and then, Lordship, thereafter, the petitioner, due to some personal reason, revoked the said power of attorney by registered deed of revocation number 39857 dated 29/2/2016. So the power of attorney was also revoked, Lordship. Now, your Lordship, I will come to power of attorney, that is page 24, annexure 2.
No, madam, we are not on that.
No, Lordship, how the process server has given report, Lordship, to show that the plaintiff and defendant, the defendant did not contested the suit even after receiving notice, Lordship. Defendant number 2 and 3. These 2 and 3 are my power of attorney holders. my power of attorney was given in favor of 3 persons, including my husband, Lordship.
No, you tell me what wrong with the report of the process server.
Lordship, in fact, there was no notice served in the residence of the petitioner, Lordship. These are all manipulated, Lordship. And defendant number, how, Lordship, the power of attorney holder?
Yeah, you have cross-examined the process servers?
Lordship, that I was not appeared, Lordship. It was cross-examined in the court itself, Lord. After cross-examination of process server, ex-parte decree, order of ex-parte proceeding was, Your Lordship, passed. So this deed of attorney was executed in favor of 3 persons. I, Mosumi Datta, as on the death of my father, late Ashim Kumar Datta Roy, being the only legal heir.
No, madam, you see, this cross-examination part, it is clearly stated by the process server that I serve summon upon the defendant Mosumi Datta Suduri.
Lordship, just to show before your Lordship how this report was submitted. No, Lordship, the plaint and Lordship, how the defendant can object to the impleadment of the petitioner in the suit, Lordship.
No.
My learned friend is appearing on behalf of the plaintiff as well as the defendants, Lordship. In this revision, whether it is maintainable, Lordship. He is representing the plaintiff as well as the defendants, Lordship.
That
So they all, Lordship, fraudulently trying to grab my land, Lordship.
Yes, are you appearing?
Yes, Lordship, for the plaintiff and the defendants, Lordship.
filed an wakalatnama which have been signed by the plaintiffs and the 2 power of attorney holders who were defendants in the suit, but between whom there has been an agreement and a settlement. They are not in conflict of interest with me. But if that comes in an impediment, I don't have any problem in withdrawing the wakalatnama of the remaining 2. That is not an issue. The issue that is
Will
pertinent
be
here,
raised great
that
issue, Lordship.
pertinent issue that involves here is, your Lordship has seen the report of the process server of 2018. She comes up even on the next date fix. She does not appear. She appears after 2 years. The incident of the survey of process, the summons by the process server is of 2018. She files a petition in 2020.
Okay.
Now, if your Lordship,
Yes,
my
madam, you
written-
come to your petition.
Yes,
Page number
Lordship.
65.
If the suit proceed with my written statement,
No.
Lordship, where is the difficulty, Lordship?
No,
I'll place my case before the learned trial.
That's all right, but you come to page number 65. The
60
petition you have filed
Yes,
under order 9 rule 7. Where you have made such averment.
Paragraph 1, Lordship, that the suit was proceeded ex parte against the defendant number 1 and the knowledge of the defendant number 1 in respect of this suit arises on 7 September 2020. I have mentioned that I came to know only on 2020. Maybe language is, Lordship, not so good, but it was not due to technicalities, Lordship. And she has already filed written statement. Petitioner already filed written statement. It was in the record. And there, moreover, Lordship, there is a decision of Supreme Court. It says on the date of ex parte order, if she wants to implead her Lordship participate from the date when the ex parte order was made, she can be allowed, Lordship, even without
It may be allowed, but in your case, the background is quite different.
No, Lordship, in this case,
there is
Lordship,
a report of the
there
process
was
server.
no process server, Lordship, no notice was served. These all are created, Lordship.
Created where you have made such averment in your petition.
No, Lordship, for this only I am saying that due to technicalities, my petition, Lordship, the technical difficulties, my petition may not be, Lordship. And Lordship, kindly see, this is a decision of Supreme Court, which says, Lordship, this is AIR 1964, Supreme Court 993, Lordship. In respect to Order 9 Rule 7 and Order 9 Rule 13, Lordship.
Maybe the background facts may be different in both the cases.
No, Lordship, kindly see paragraph 5, Lordship. I have already submitted before your Lordship that behind my back, Lordship, the 2 of the power of attorney holders.
That's all right, but you have never mentioned the said fact in your petition.
Only, Lordship, technical.
No.
Lordship, there is no such explanation in the petitions, Lordship. paragraph 5, Lordship, that page 8. The appellant thereupon moved the High Court of Allahabad in revision against the order passed against the refusal of his application in suit number so-and-so alone, and apparently obtained a stay of delivery of the judgment. This application was disposed of by the High Court on so-and-so when the following order was passed. It was considered that no ex-parte decree has yet been passed. The only order passed is that the case shall proceed ex-parte against the appellant. In view of the fact that no decree has yet been passed, the setting aside of the ex-parte order was not absolutely necessary. After referring to the decision of this court in Sangram Singh versus Election Tribunal, the learned judge added, it follows that even though the ex-parte order had been passed, the applicant could appear and take part in the case from the stage at which the ex-parte order had been passed. The only thing he would not claim was to be relegated back to the old position as if he had not absented himself on the date fixed. So, Lordship, in this case, when ex-parte order was passed, there was time to file written statement. On the very first date, the learned trial court proceeded with the trial ex-parte, Lordship. So behind already, Lordship, that power of attorney order, power of attorney was revoked by the petitioner in favor of the defendants. Now the taking the benefit of that power of attorney, Lordship, the specific performance of contract suit is to be decreed, Lordship, behind my back, and I am the owner of that property. Already there is a suit pending for eviction of the defendants. Whether that suit is at all maintainable, Lordship, for that only
No,
my
we are
written
not
state-
the merit of the case.
Lordship, my impleadment is necessary, my presence is
No,
necessary, Lordship.
You have already entered appearance. You have been allowed to cross-examine the witness. Anyway, we'll see. Hardness.
Lordship, I am relying on another judgment that is
also
Thamma, Lordship.
Yes, sir.
In this case, Honorable Supreme Court, even after passing of the decree,
Respondent, order reserved. Harness it to the court master.
Lordship, 2019 7 SCC, Lordship, only paragraph 6, Lordship. And you see, even after passing of the decree of suit for specific performance of contract, Lordship, when execution is over, thereafter Supreme Court returned back the suit to be decided in presence of the defendant. And deeply obliged, Lordship.
Item fixed at 2 p.m. Item number 33 for those. Blood, after recovering from a soup, Milord, I have filed an IA. Perhaps the number is 2356 that has been listed on as a production matter. 2356, Milord. But this petition I have filed under order 23 rule 1 and 3 of the CPC Milord for permitting, praying for the permission to withdraw all the applications or the petitions that has been filed earlier in CRP serial number 6944/2021 dated 16/8/21 along with all the IAs filed therein. And the only prayer before your lordship is, my lord, that the judicial time that we have spent over here may kindly be ignored while dealing with the delays petition for the fresh set of petitions that we have already filed. Those are also before your lordship, my lord. But I'm coming to all the petitions one after another, my lord. This is a petition, I believe, lordship, what lordship has taken is order 23 rule 1 and 3.
No, you want to withdraw.
All that CRP that is pending, along with all IS filed therein, my lord. If lordship allows me to withdraw with a liberty, then my lord may takes up the RSA and the petitions I files therein, my lord.
Okay, heard. Does any objection?
My lord, he can withdraw, my lord, there are no objection on
objection.
that matter.
Okay.
However, my lord, subsequently, he has also filed RSA. In that, my lord, I believe there must be
some delay.
Delay. So, that in the.
I'm
delay-
coming to those, my lord.
Notice may be issued in the delay in the connected RSA, my lord.
Is it
Separate
necessary?
yes also.
Because
filed.
section 14 is already there.
My lord, section, that is why, my lord, I filed this petition under section 14 also.
Yes, so far 14 is concerned, section 14, time spent in this proceeding he will get, but he has to, for the purpose of calculation, that period will come. For purpose of calculation.
That is only, my lord, because otherwise, if it is deducted, my lord.
Yes.
Hardness or is for the applicant, then indicators, Lord council prudence for the opposite party. This application under order 23 rule 1(3) reading section 151 of the Code of Civil Procedure is prepared by the applicant for according permission to withdraw the CRP. Paying CRP number
CRP serial number, my lord, 6944/2021, dated 16th August 2021.
along with all interlocutory applications connected therewith, with liberty to file appropriate petition before this court. Sir, does learned counsel for the opposite party submits that he has no objection. There are taking note of the submission of learned counsel for both the parties. And also considering that even facts and circumstances on the record is over. We meet appropriate to accord permission to Mr. Somwa to withdraw the CRP numbers also along with all the interlocutory application conducted thereto. In terms of above this, I stands closed.
My lord, in that, my lord, perhaps may,
Okay,
has to be
how the
mentioned.
liberty will remain with the petitioner to approach this court again by filing appropriate petition. Yes, madam, pardon?
MSMD Bora
MD Bora for respondent number?
5.
Respondent.
My lord, now there is another petition, we have filed an RSA. Now there will be a delay in the RSA. And that RSA, there is a IA, my lord, IA perhaps 235725.
Yes.
I've explained this delay is there, my lord. And since lordship has permitted to withdraw the previous applications and the time spent therein, my lord. And my lord, the explanation is at page 6, my lord. These are some situations where, my lord, this is beyond control of the management of the corporation, my lord. And when it is filed, my lord, and we all know it was with Mr. J. Roy, senior counsel now. He fell sick even while doing a case here in the court itself, and he was indisposed for quite a long time. The file was with him. And prior to that event, the file was kept under lock and key by an officer of the corporation, and he left the corporation. Actually, he was the chair. Then it was searched and found after a very long time. And when this matter was taken up for filing, we did not find, the lawyers did not find the certified copy. Then we have to apply for the certified copy again. Then the law officer who was appointed, she was pregnant and she was on maternity leave, then child care leave. Then ultimately we filed the CRP wrongly again on 16 August 2021. The calculation that, my lord, we have shown in paragraph 6, page 8, my lord. It is 633 days. The other day, my friend was correct, my lord. The delay is 633 days. After deducting the period, the holiday that was given by the Honorable Supreme Court because of the COVID. Now, my lord, for delivering the substantial justice, my lord, if lordship issues a notice, my lord, it will prejudice my cause because of the fact that there is an execution proceeding pending, and
So when the next date is fixed in that process?
6 August, my lord.
6 of
6th of August.
But in this application, we have to give a chance to them also. to
Of course,
file
man,
objection.
I am not opposing to that. My friend will definitely get a chance to reply. But what my sincere prayer is, my lord, in the interim, my lord, if for a while, till my friend appears, my lord, my friend will come up with an judgment of the Supreme Court, I know that. But even if, my lord, I also can show the judgment of the Supreme Court. It says, my lord, when substantial justice to be delivered, sometime, my lord, it has to be, the procedural mercy has to be tempered with
Next that is fixed before the executing court on
6th of August.
6th of August. Prior to that, we will try. to
Yes, if
put
my
some-
friend come up,
No, here, my lord, my problem is that, my lord, in the CRP proceeding, I was engaged. Now, my lord, in the second appeal, just now I have come to know they have filed a RSA. And here, my lord, whether they engage me, my lord, therefore it will be prudent if he take a dusty service.
I will do that, my lord. I will do that
And
also.
thereafter, if the client engage me in this subsequent
No,
petition.
Mr. Das, you can obtain necessary inspection in
Yes.
this regard as to whether you will be able to enter appearance in this.
I will provide all copies to him today itself.
Before 6 months, that may fix, I will apprise this.
I will supply him all the copies.
Man.
No, can we fix on 29?
Yes,
Wednesday?
okay. Yes, my lord. I am here, 29.
Mr. Das?
Madam.
Uh,
Or my lord, 31st, my lord, because only one side he stays, my lord, somewhere else, not in Dibrugarh. So that the communication would be
can
problem.
obtain inspection
31st.
over phone also.
29 is okay, my lord.
29.
We'll make an attempt.
Ma'am.
Heard Mr. Samuel, learned counsel for the applicant. This
OPT report.
interlocutory application under Order 41, Rule 3, capital A. Read with section 151 of the Code of Civil Procedure is prepared by the applicant. Read with section 5 and 14 of the Limitation Act 1963 for condonation of delay of 633 days in preparing an appeal against the judgment and order dated 22nd of March 2018 passed by the learned civil judge Dibrugarh in title appeal number 11 of 2013. Let notice be issued to the respondent, returnable on 29th.
Cannot be on 30th.
30th,
Please.
okay, 30th July. Since Mr. Das, learned counsel, for the respondent opposite party number,
Matlab, here matlab problem is 2 and 4.
2 and 4.
No, 2 and 3, matlab, I believe, matlab, on earlier occasion, I apprised this honorable court, they expire.
Substitute, my lord, immediately, my lord, after having the information.
2, 3 and 4.
No,
No, matlab, 2 and 3.
2 and 3. my lord.
2 and 3. 2 and 3. And Madam Bora for?
Another part.
9.
Another part.
Okay, okay.
My lord, here, my lord, that I was submitting respondent number, pro forma respondent number 2 and 3, they expired, my lord. I will be appearing for 1, 4 and 5.
Well,
1, 4 and 5.
Yes.
1, 4 and 5.
There-
No formal notice is required to be issued, however, notice is required to be issued.
extra copy, my lord. I'll put.
However, extra requisite copy of the petition may furnish to him during the course of the day.
No, right now I'm doing.
Place the matter on 30th of July. In the meantime, Mr. Das shall obtain necessary instruction in respect of appearing in the RSA number.
At 2 PM, my lord, can it be fixed?
In the connected RSA, along with this interlocutory application number 2357 of 2025.
My lord,
List on
Okay.
At 2
There's
PM.
a submission, my lord, that pro forma respondent 2 and 3 expired. That may be kindly noted.
Okay. Mr. Das, learned counsel for the respondent number so also pointed out that respondent opposite party number 2 and 3 already suffered demise.
Yes.
That Mr. Somo, learned counsel for the applicant submits that he will take necessary step for impediment of the legal heirs of respondent opposite party number 2 and 3 on next day.
Next day. Well, if it's not inconvenient, can it be mentioned at 2 PM?
Okay. Restitution
what-
matter
yes.
at 2 p.m.
Well, one more thing, Milord. In the first IA number 235625, perhaps I have not heard, Lordship might have mentioned, but I have not heard.
Regarding this section 14.
Yes, yes. That may be mentioned.
Obliged.
I'm deeply obliged.
But Mr. Somoa, it is provided in the act itself. Whether there is whether observation of the court is necessary.
Well, since it is discretion of the court, Milord. It is not automatic, I believe.
Okay.
Ultimate thing is the power must be there. Power must
Power
be
is,
there.
power is there. It is
Then
depend.
it is no problem.
It depends on the court to exercise or not to exercise.
Any item? 15. Item for referring to mediation.
May I please, your lordship, after condonation of delay, this appeal has been, this matter has been listed for the first time. So it ought to have been,
admitted.
it ought to have been either listed for admission or your lordship may admit the appeal.
Anyway, we can admit the matter.
And your lordship may pass an order in the stay application also.
Here appellant is
Is an insurance company, Lordship. The matter is that, Lordship, the victim was a government servant and his family is getting entire salary,
Pension.
Lordship. Yes, Lordship. So that scheme is applicable in this case, Lordship. So there is no loss of dependence.
okay. Heard Mr. Soikia. Learned counsel for the appellant and Mr. Mondal for the respondent number.
1 to 4.
Please. You are for respondent number
1, 2, 3, 4.
1, 2, 3, and 4. All the respondents?
No, your lordship.
Owner and
Claimants
driver
is
will
not-
have to service, Lordship. He is for claimant, Lordship.
1, 2, and 3.
And 4 also.
There are only 4 respondents here.
5 and 6 are also there, Lordship.
Owner driver.
Okay. Respondent number 1, 2, 3, and 4. This appeal under section 173 of the MB Act 1988 is directed against the judgment and award dated 9/2/2024. Passed by the learned member, motor accident claim tribunal, Nalbari, in MSC case number 1 of 2021, syndicate date. It is to be noted here that by impugned judgment and award dated so and so, the learned tribunal is directed the appellant herein to pay the sum of rupees 76,08,695 rupees, paying the compensation with interest at the rate of 6% from the date of filing the claim petition, that is 11/2/2020. Where is the memo of appeal and the grounds mentioned therein? Then also peruse the impugned judgment and award dated so and so. Admit, issue notice to the respondent returnable late for it. However, no formal notice is required to be issued to the respondent number 1, 2, 3, and 4 since Mr. Mandal entered appearance and received notice. However, extra requisite copy of the petition furnished to him during the course of the day.
Your lordship, it has already been furnished. Copy has already been furnished by my learner.
Resist will call for the record from the learned tribunal. Leaves the matter after 4 weeks. IA number 2063.
It is for stay, Lordship.
Stay.
Yes, Lordship.
Deposit 50% of the awarded amount. Heard Mr. Mr. is a Soikia, learned counsel for the applicant, and Mr. Control for the respondent number 1, 2, 3, and 4. This application under Order 41 Rule 5 reduced section 151 of the Code of Civil Procedure is prepared by the applicant. Reliance General Insurance Company Limited for staying operation of the impugned judgment in order dated 9/2/2024, passed by the learned member, motor accident claim tribunal, Nalbari, in MSC case number 1 of 2021, which indicated date. Mr. Turkey Learned Counsel for the applicant submits that connected MSc appeal has already been admitted by this court and notice has been issued to the respondents and the record has also been called for. And as such, there is a requirement for staying operation of the impugned judgment in award dated 9/2/2024 till disposal of the MSc appeal. And that the applicant is willing to deposit a sum of 50% of the awarded amount. Third, taking note of the submission of learned counsel for both the parties, this court is inclined to allow this application, subject however to depositing of 50% of the awarded amount before the registry of this court within a period of 4 weeks from today.
Your Lordship, liberty may be granted to me to withdraw.
Lordship, they will not be entitled to that much, Lordship. It is, they are getting all salary, Lordship. They are already, there is no loss of evidence.
First, the deposit the amount, thereafter you file an application, we will see.
Obliged.
Item 20,
Obliged, Your Lordship.
Okay, the issue in very brief is that I filed a petition under Order 23 Rule 1(3) for withdrawal with liberty. However, my petition was partly allowed. It was allowed to be withdrawn, but without a liberty, Your Lordship. This is the case. Now, just going to the background of the case, Your Lordship. A suit was filed in the year 2022.
Where is the impugned order?
Impugned order is at
Page
page 59, Annexure 8.
59.
59. The court has discussed and says that the grounds assigned does not constitute to be a formal defect. And as such, the liberty as sought for cannot be granted because there is no formal defect.
Where it is observed, paragraph number?
Now flip at the last page, page 62. Second last paragraph, Your Lordship. In view of the aforesaid facts and circumstances, in my considered opinion, since the case of the plaintiff does not fall within the ambit of the concept of formal defects under CPC, the plaintiff is not entitled to the relief of liberty as to file afresh on the same cause of action as except the relief of withdrawal. Accordingly, the instance suit stands disposed of on withdrawal. However, no liberty is granted to the plaintiff to file afresh on the same cause of action. This is the situation, Your Lordship. Now, just before going to the
So the trial court has observed that the defects are not formal defects.
not formal defects, Your Lordship.
No, is there any requirement that if the defects are not formal defect, then liberty cannot be?
The provision says two ways, Your Lordship. either there has to be a formal defect or there has to be a sufficient ground, Your Lordship. Because if we go to Order 23, Your Lordship, Order 23, Rule 1(3), Your Lordship, if I may read, where the court is satisfied that the suit must fail by reason of some formal defect, or that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of a suit or a part of the claim, it may, on such terms as it thinks fit, grant the plaintiff permission to withdraw from such suit or part of such claim, with liberty to institute a fresh suit in respect of the subject matter of the suit or a part of such claim. So the provision, Your Lordship, it is clear that there may be two reasons for withdrawal with liberty, Your Lordship. Either formal defect as regards to clause A, or there must be sufficient ground for allowing the plaintiff. Now the court in this impugned order, the aspect of sufficient ground is not discussed, Your Lordship. Only the aspect of formal defect is discussed. Before that, Your Lordship.
Whether there is any sufficient ground?
Yes, Your Lordship. I'll explain the facts as well, Your Lordship. Just briefly, Your Lordship, the suit was filed in the year 2022. And after filing of the suit, Your Lordship, the WS was filed. At that stage, there was a change in the advocate. And after the change in the advocate, Your Lordship, they have found out that the plaintiff's own title was not specifically averred in the plaint, Your Lordship. That how, from where he has got his own plot of land, the plaintiff has never averred that. And there were certain other cause of actions that were not stated. Under such circumstances, they filed a petition under Order 6, Rule 17, Your Lordship, for amendment of the plaint. That amendment petition, Your Lordship, there was many things to be inserted. And the court rejected that amendment petition, saying that all these things are new facts and they may not be allowed to be amended so extensively. As such, it is rejected. Immediately on the next date, Your Lordship, the plaintiff said, if it is not amended, ultimately my case is going to fail. So they prayed for withdrawal with the liberty to file afresh, Your Lordship. And here comes the order, Your Lordship. The amendment was initially not allowed, which was not challenged. And thereafter they filed for withdrawal. Withdrawal was allowed and liberty was not granted. Now, Lordship, the plaintiff is in such a situation, hit by Order 2, Rule 2, that he cannot file a case. He is basically non-suited. And this order, Your Lordship, how it is bad in law, I'll just show. The different high courts as well as our high court has said, when there is a petition for withdrawal with a liberty, Your Lordship, the court has to either accept that petition and give the liberty or reject the petition as a whole. The court cannot allow it to be withdrawn and then not give the liberty. This is not the correct proposition of law.
Where is the?
There are judgments. First of all, Your Lordship, I'll rely on three judgments in this regard. First of all, a Patna High Court judgment, Your Lordship, very old judgment, Your Lordship, 1921, 1920 SEC online, AIR 1921, Patna 360, short order, Your Lordship. The second paragraph, if I may read, the facts are that the plaintiff prayed for a permission to withdraw his suit with permission to bring a fresh, but the Munsif simply allowed him to withdraw his suit and has refused him permission to bring a fresh suit. This is obviously a wrong order. The Munsif, if he thought that the permission to file a fresh suit should not be granted, should have dismissed the application and have either heard the suit on the merits or have dismissed it for want of prosecution if the plaintiff refused to proceed. Instead of doing this, however, he has divided the petition in two parts and has attempted to treat the application as one under the first part of Order 23, Rule 1, Clause 1, where no liberty is claimed. As such, it was set aside. Thereafter, there is a Calcutta High Court judgment next, Your Lordship, a short one. It is also a very old judgment, 1925. The plaintiff petitioners during the hearing of their suit number so and so in the court of second municip of so and so applied for permission to withdraw the suit with liberty to bring a fresh suit. The municip allowed them to withdraw the suit without permission to bring a fresh suit and directed the defendants to get their cost from the plaintiff. This order was passed in connection with two suits, but this rule is only connected with suit number so and so. The municip's order was wrong. Wrong is clear from the decision of the Bombay High Court in so and so, as they're pointed out, where the plaintiff does not desire to withdraw from a suit unless with the liberty to bring a fresh suit, the court considers such liberty should not be granted. The proper course is simply to dismiss the application. And then our High Court, Your Lordship, a recent one, 2019 4 GLR 254, Mukut Fukan versus Union Bank of India. If I may read paragraph 6, Your Lordship, in this one. Considered the submission of both the learned senior counsel, on a plain perusal of the provision of Order 23 of the CPC, there is no specified categories of cases under which leave to file a suit afresh can be granted. The court is given discretion under Order 23 Rule 1(3) of the CPC, but before the application of the discretion by the court, it must be satisfied that the suit must fail by reasons of some formal defects, or there are sufficient grounds for allowing the plaintiff to withdraw and institute a fresh suit for the subject matter of a suit or a part of the claim, and only on fulfilling the said condition, the permission to withdraw the suit must be granted with the liberty to institute a fresh suit. The petitioner failed to show any cogent ground that there are formal defects in the suit, but even then, the learned court below partly allowed the petition to withdraw the suit, but without any leave. The said application of the discretion by the court below cannot be accepted as proper, inasmuch as while passing the impugned order, the learned court below failed to take note of the provision under Order 2 Rule 2 of the CPC, wherein it specifically stipulated that in respect of any relinquishment of a part of the plaintiff's claim and intentionally relinquishes any portion of the claim, the plaintiff shall not afterwards sue in respect of the portion so omitted or relinquished. The learned court below failed to consider the leave stipulated under Order 23 Rule 1 Sub-Rule 3 of the CPC is only to protect the plaintiff from the provision of Order 2 Rule 2 of the CPC. The impugned order, if allowed to remain, would cause the plaintiff petitioner prejudice in as much as the plaintiff petitioner shall be debarred from making the claim further in other suit, Your Lordship. Accordingly, I am the considered opinion. It is satisfied that the revision petition must be allowed, thereby setting aside the impugned order of so and so. So this provision, Order 23 Rule 1(3), is basically a protection given to the plaintiff.
No, that's all right, but the learned trial court has observed that there was no formal defect.
No formal defect. Now I'll come to that
But,
aspect as well.
You saw the other sufficient ground.
Yes, I'll come to that aspect now, Your Lordship. For that, I am also relying on another judgment. First of all, Your Lordship, 2017 5 SCC 63, Your Lordship. This is also referred by the learned court below, V. Rajendran versus Anna Swami Pandian. In this case, Your Lordship, in para 10, if I may read, para 10. In KS Bhukti versus Kokila, it has been held that it is the duty of the court to be satisfied about the existence of formal defect or sufficient grounds before granting permission to withdraw the suit with liberty to file a fresh suit under the same cause of action. Though liberty may lie with the plaintiff in a suit to withdraw the suit at any time after the institution of the suit on establishing formal defect or sufficient ground, such right cannot be considered to be so absolute as to permit or encourage abuse of the process of the court. The fact that the plaintiff is entitled to abandon or withdraw the suit or a part of the claim by itself is no license to the plaintiff to claim or to do so to the detriment of the legitimate right of the defendant. When an application is filed under Order 23 Rule 1(3) of CPC, the court must be satisfied about the formal defect or sufficient ground. Formal defect is a defect of form prescribed by the rules of procedure, such as warrant of notice under section 80 CPC, improper valuation of suit, insufficient court fee, confusion regarding identification of the suit property, misjoinder of parties, failure to disclose a cause of action. Formal defect must be given a liberal meaning, which connotes various kinds of defects not affecting the merits of the plea raised by the either of the parties, Your Lordship. Here it says that
You tell me
Yes,
if
Your Lordship.
another sufficient ground exists.
Yes, Your Lordship. Thereafter, the next judgment, Your Lordship, that is Odisha High Court judgment. This judgment says that it has to be given, formal defect has to be given a liberal connotation, Your Lordship. In this case, Your Lordship, the defects that we have pointed out is that the plaintiff did not disclose how he has entered into the property, what was his own title to the property. Whether it was purchased or it was inherited, he did not say. He said, this is my property, they have encroached. Next, the Odisha High Court judgment 2019 judgment, Your Lordship. Here, para 16, if I may read. Last page, Your Lordship. The expression formal defect has not been defined in CPC. The subject of enumeration belongs to a broad-based genus as well as narrow-based genus. Thus, the question of application of the principle of adjudicem general genus does not apply. Clause B cannot be constricted by Clause A. There was a situation, Your Lordship, in some high courts, it was said that some other sufficient ground has to be similar to the formal defects, because these are two different terms. Some high courts were of the opinion that the other sufficient grounds will also have to be read in adjudicem generis with formal defects only. So this judgment clarified that it cannot be done so. Clause B cannot be constricted by Clause A, where two alternatives are provided. The expression other sufficient grounds occurring in Clause B of subrule 2 of Rule 1 Order 23 cannot be restricted to the defects of a formal character. The words are wide enough to take within its sweep other defects as well. And finally, Your Lordship, the one-page Supreme Court judgment of a three-judge bench that I have handed over now, Your Lordship. 1981 judgment. Beniram. If I read the judgment from the starting, we have heard Mr. Fatke, learned counsel for the appellant for some time. After discussion at certain stage, a contention was advanced by Mr. Fatke on a particular point in the case, and he has conceded that it is not the case pleaded in the plaint. At this stage, Mr. Fatke wishes to withdraw the suit with liberty to file a fresh suit on the same cause of action or on a different cause of action. Having considered the fact that non-pleading may prove a technical impediment and may result in dismissal of the appeal, which may impede a fresh adjudication if a point is to be made through, though belated, we consider it just and proper in the interest of justice to permit appellant plaintiff to withdraw the suit with a liberty to file a fresh suit as stated herein above. Accordingly, we grant the liberty. This is a case before a three-judge bench of the Supreme Court, Your Lordship. At that stage, it was held that non-pleading of certain facts also entitles the plaintiff to withdraw the suit because it may turn fatal to the entire suit itself. Here, the prayer for, in this case at hand, Your Lordship, the prayer for withdrawal was made at the very first instance. First of all, we tried to amend. When amendment was not allowed, we prayed for withdrawal with a liberty to file afresh because amendment may become clumsy. Too many facts had to be brought in. We did not challenge that. We prayed for withdrawal to file afresh. Before the commencement of the trial, before the issues were framed, and the court did not allow that liberty. First of all, without allowing the liberty, the court ought to have either heard the case on merits, because the court cannot segregate the prayer and allow only withdrawal and not the liberty. If at all we understand that non-pleading of facts, because this Supreme Court judgment, three-judge bench, it has taken into consideration that non-pleading of facts is also, if it is fatal to the case of the plaintiff, liberty can be granted. And this was done at the page of the Supreme Court.
You have not pleaded.
Yes, Your Lordship. Yes, Your Lordship. My petition.
Where you have mentioned it?
Yes, Your Lordship.
Your petition is at page number?
Page number 45. Annexure 6.
Yes.
Para third, Your Lordship. On receipt of the brief of the case, the newly engaged advocate for the plaintiff has very carefully and meticulously gone through the entire case record and found that there are 7 inherent formal defects exist in the suit pleadings. As such, the suit cannot be allowed to proceed any further, causing untold sufferings and irreparable loss to the innocent plaintiff. However, save so-and-so. Then if I come to the para 4, Your Lordship, it is submitted that the inherent formal defects in the suit caused due to deficiency of the previously engaged advocate drafted the plaint and without elaborating actual facts as stated and divulged by the plaintiff. It is pertinent to mention here, since the above deficiency formal defects came to the knowledge after the taking knowledge of the plaintiff very recently, immediately after engaging the advocate on taking back the brief from the earlier advocate. To protect the interest of the innocent plaintiff, it is essential that the present suit is required to be withdrawn with liberty to file a fresh suit. Para 6 lays down all the defects, Your Lordship. It is elaborate, Your Lordship, because the title of the plaintiff himself, the para 6.
No, you have mentioned about the formal defects. But,
Yes, Your
what
Lordship.
about your this
In paragraph 1 and 2 of the plaint.
pleading of the facts?
Yes, Your Lordship. In paragraph 1 and 2 of the plaint, the plaintiff has submitted that there is a plot of land measuring so and so that is out of the scheduled land. He is the owner of 1 bigha 2 katha. But he has not stated as to how he is the owner of 1 bigha 2 katha. That has to be brought into record, that he has purchased it by way of a sale deed. So we prayed that this has to be inserted, Your Lordship. Initially, we prayed for insertion by way of an amendment. But since too many facts were pleaded, the amendment was not allowed. The court has observed, we have annexed that order as well. The court has observed that so many amendments, you are trying to bring new facts, we cannot allow it. If I am not allowed to amend my plaint, I have not stated my facts properly. If I am not granted the liberty, I will be hit by order to rule to as.
Yes, Mr. Hussain.
Yes, please, Your Lordship. So for the facts pleading, when my learned faith referring the full bench judgment of Supreme Court, my lord, I'm starting from there, my lord. My lord, so for the facts, my lord, in the amendment petition order 6 rule 17, my lord, while filing this, my lord, it appears that the plaintiff has stated a branch of facts, which is, my lord, completely bring the new facts, my lord. And that apart, my lord, petitioner trying to bring in the plain, in the amendment plate, just to fulfill the lacuna by making a clever drafting. So therefore, my lord, his amendment petition was rejected. Complete.
No, that we are not testing that order.
That is. That apart, my lord, when this amendment was rejected, my lord, he filed this 2313, my lord. If Your Lordship, my lord, I am also referring the same judgment of the 2017, my lord. Just for a moment, just reading again, my lord. When an application is filed under order 2313 CPC, the court must satisfy, my lord, paragraph 10 of the bottom 5 lines about the formal defect and sufficient ground. Now let us first, my lord, see the formal defect.
Paragraph number 10 of which judgment?
My lord, 2017 5 SCC.
2017 5 SCC. Okay. Paragraph number 10.
10, last 6-7 line, my lord. When an application is filed under order 23 rule 13, the court must satisfy about the formal defects or sufficient ground. The formal defect is a defect of form prescribed by rules of procedure such as want of notice under section 80 CPC, my lord, is given. Improper valuation of the suit, my lord. Nowhere mentioned in the, my lord, petition. Insufficient court fee, that is not there. Confusion regarding the identification of the suit property, well, let's say in the main plan and the petition 2313, same. It is not the same. It is not that at the time of filing plaint, it was improper of the.
No, that's all right.
Gender of party is not
the
there.
trial court has also observed that there is no formal defect.
Exactly, my lord.
Even then, the court has allowed them to withdraw the case,
My lord.
but refused to grant liberty.
Liberty.
That part of order is being challenged here.
My lord.
And according to him, this he has
See,
not
High Court
pleaded
judge-
some facts in the plaint.
My lord. If your lordship see their petition,
And that is one of the sufficient ground according to him
my lord,
for granting him liberty.
liberty.
Now, what is your submission on this point?
My lord, yes, my lord. If your lordship page 45, the petition under order rule 20, order 23, rule 1(3), my lord.
Page number 45.
My lord, this is the petition.
Yes.
I was seeking for my lord, withdrawal of the liberty. This petition, my lord, narrated, my lord, again, para 3, 4, 5. These are with regard to, my lord, formal defects. So, my lord, there is no formal defects. My lord, start from 6, my lord, onwards. My lord. Now, they are trying to project the sufficient reason. My lord. 6A, 6, 7, then, my lord, 8, then, my lord, prayer, my lord. Now, these, my lord, all these are, my lord, by way of the, if your lordship A, the schedule of this is not a sufficient reason, my lord. Even not a single word assigned in the prayer, nowhere there is a sufficient reason. Please allow this petition with the liberty.
No.
Just repeated the whatever the praise in the order.
No. Mr.
6 rule
Mr.
7.
Hussain,
My lord.
you see, he has categorically submitted
Ma'am.
that he has not mentioned in the plaint how he become owner of the land. Is it not a sufficient ground?
My lord, your lordship kindly consider when this, how he got after
Besides,
this.
Mr. Hussain, there is also decision of this court
Ma'am.
that once granting liberty, no, sorry, allowing to withdraw the case, refusing
not
to
giving
grant
liberty.
is not sustainable. There is order of this court.
My lord, and I am referring a judgment of
Then Mukut Pokon versus United Bank of India and others.
my lord. In your lordship, my lord. Yes, 200 ISCC, my lord. I am just referring on judgment. Para 13, my lord, may I read, my lord? But it will be prejudiced to that at the same time of the defendant, my lord. Para on one paragraph, my lord, it will take 10 minutes. 2005 SCC, my lord. The provision, para 13, my lord. Your lordship has at the same time kindly appreciate the other side part of the suit, my lord. Defendant side, my lord. The para 13, the provision in order 23 rule 1 CPC an exception to the common law principle in non-suit. Therefore, on principle and application by plaintiff under sub-rule 3 cannot be treated on a par with an application by him in exercise of the absolute liberty given to him under sub-rule 1. In the former, it is actually a prayer for concession from the court after satisfying the court regarding existence of the circumstance justifying the grant of such concession. No doubt, grant of leave envisaged in sub-rule 3 of rule 1 is at the discretion of the court, but discretion is to be exercised by court with caution and circumspection. The legislature policy in the matter of the exercise of discretion is clear from the provision of sub-rule 3 in which two alternatives are provided. First, where there is court is satisfied, a suit must fail by reason of some formal defect. And otherwise, the court is satisfied that there are sufficient grounds for allowing the plaintiff to institute a fresh for the subject matter of a suit or part of claim. Clause B of the sub-rule 3 contains the mandate to the court that it must be satisfied about the sufficient of the ground for allowing the plaintiff to institute a fresh suit for the same claim or part of claim on the same cause of action. The court is to discard discharge the duty mandate under the provision of the court on taking into consideration all relevant aspects of the matter, including the desirability of the permitting the party to start a fresh round of litigation on the same cause of action. This become all the more important in case where the applicant under Order 23 Rule 1 is filed by the plaintiff at the stage of appeal. Grant of leave in such a cases would result in the unsuccessful plaintiff to avoid the degree or decrease against him and seek fresh.
No, that was in the appellate stage. Sir.
My lord, and of course, my lord, in the clean state. It may also be result in the contesting defendant losing the advantage of adjudication of the dispute by the court or the courts below. So grant of permission or withdrawal of a suit with the leave to file a fresh may also result in annulment of a right vested in the defendant or even a third party. So that is my lord. At the same time, your lordship has to consider, my lord, the appellate or second appeal or should apply in minds. Your lordship also consider, my lord, once order 6 rule 17 gone, they come with the new weapon. Let me allow on the same sets of my lord facts and taking the lacuna of the advocate.
This decision is actually different from the present case.
But at the same time, your lordship also appreciate, my lord.
Okay.
And that judgment, my lord, it was observed in the 2017 judgment. If your lordship allow him, my lord, a cost, my lord, heavy cost is to be imposed.
Okay.
My lord. That might make it.
Learned counsel for the petition and Mr. Hussain, learned counsel for the expert. Argument concluded, order rejected.
A heavy cost is to be imposed.
Pardon?
Cost is to be imposed.
Why?
The cost. The judgment of the 2017 is also allow under giving the cost.
Item 21.
We'll see.
But your lordship, this is a petition, your lordship, with regard to the guardianship, your lordship, and ward act, your lordship, this petition has been going on in the family court, your lordship.
What's for the other side?
Your lordship, they have not yet appeared, your lordship, but they have.
Notice was served?
Yes, your lord, justice service was also done, your lordship. And your lordship, my primary grievance is that my interim prayer, your lordship, for visitation right has not yet been considered, your lordship. It's been around 2 years, your lordship. And your lordship, if your lordship move on to one petition, your lordship, that is petition number 81 of 84, which I've annexed as on page 39.
Let us see the impugn order.
Your lordship, no order has been passed, your lordship. My prayer for visitation rights, your lordship, for that I have been praying for a hearing, your lordship. This honorable court had ordered it at 2/4/2025, your lordship, has requested the court below, your lordship, to conduct a hearing, your lordship. Your lordship, then also nothing has been done.
By which order?
2/4/2025, your lordship. I have been filing one petition after another, your lordship, but no hearing, your lordship. Nothing has been done, your lordship. She remains absent.
2/4/2025.
Lordship.
No, in that order, there was no direction.
No, there was a request, your lordship.
Where?
On 2/4/2025. Your lordship,
Read it.
I'm sorry, 2/5, your lordship, 2/5/2025. The operative portion is on is starts from para 9, your lordship. In the meantime, this court would request the learned court of the Principal Judge Family Court number 1, Kamrup Metro Guwahati, to expedite the hearing in respect to the interim prayer of the petitioner on the next date so fixed, so that the petitioner is also able to meet his child, who is presently around 3 years old. So, your lordship, after that, your lordship, the child came with the mother in the court. I was allowed to see, but he fails to recognize me. Obviously, your lordship, for 2.5 years, He has not seen me, your lordship. And hereafter, again, she remain absent, your lordship. And your lordship, in the last, before the last birthday of August 3rd, I filed a petition just to allow me to meet my child on his birthday. That remained, your lordship, without hearing, that became infructuous. Now August 3 is again coming, your lordship. And there are several other petitions, your lordship, which has been filed before this, before the principal judge family court, your lordship. Not a single hearing has been conducted, your lordship. No written statement, nothing. She remains absent. Sometimes steps are taken by the council. Sometimes she remains absent.
Okay, we'll examine the record. We'll call for the record.
Your lordship, maybe records were here, your lordship. I'm not sure, your lordship. The earlier, no.
Record has already been called for. When it was called for?
Maybe your lordship. But can copy. Okay. Your lordship, in the cause list is shows with PCR. What's PCR mean? Trial court record. LCR. TC, trial court record.
So you have filed a petition in the month of July 2024.
Lordship. No, no, your lordship, the petition before the trial.
In the said petition, no objection was filed by the other side. Heard, Mr.
I have seen your motion.
Learned
And the-
counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner has tried for issuing direction to the learned principal judge family court number 1, Conduct and Guwahati in Miss within the G case number 163 of 2023. To pass interim order in favor of the petitioner by allowing him visitation right to meet the minor son without further delay and to expedite the disposal of the connected petitions. Being petition number 82 of 2024, 1427 of 2024, and 1428 of 2024. And also the main petition. Being Miss within the Z case number 163 of 2020. So Hussain learned counsel for the applicant submits that the applicant has filed the Miss Z case number 163 of 2023. Before the approved of learned principles as family code number 1, Kamrup M. Guwahati. For granting guardianship and custody of the minor child of the petitioner. And pending disposal of the said petition, the petitioner has also filed a more petition seeking visitation right in petition number 82/2024, 1427 of 2024, and 1428 of 2024. On 29/7/2024. But the same are yet to be disposed of. Yet to be disposed of. And under such circumstances, Mr. Hussain, learned counsel for the applicant, submits that the learned trial court, no, learned principals of family court Kamrup M may be directed to dispose of the aforementioned petition and also to dispose of the main petition being Ms. Z case number 163 of 2020. Having heard the submission of Mr. Hussain, learned counsel for the applicant, I have carefully gone through the petition and the documents plus record, and also perhaps the scanned copy of the record received from the learned principals as family court number 1, Kamrup M. Guwahati. It appears that the applicant has preferred two applications on applicability on 29/7/2024 for allowing the petitioner and his family members to meet his minor son. Then another petition for visitation right, stroke allowing the petitioner to meet his minor son. And thereafter also file another petition, being petition number 1427 of 2024 to allow the petitioner and his family members to meet his minor son, but the said petitions are yet to be disposed of. Though copy of the said petition were furnished to the opposite parties for filing their objection. In the given facts and circumstances on the record, this court is inclined to dispose of this petition by directing the learned Principal Judge Family Court to dispose of all the 3 petitions filed by the petitioner within a period of
Your Lordship, the next date is on 1st of August.
so
August, Your Lordship. My son's birthday is on 3rd of August, Your Lordship. Your Lordship, on the last date already, Your Lordship, ex-parte proceeding has been drawn, Your Lordship, 36/2025, last date. Because the respondent has not appeared, Your Lordship. I have that order, Your Lordship. The thing is that against you will come and file an application and everything will hang in the limbo.
uh, as soon as practicable, the learned counsel for the petitioner producing an order dated 30/6/2026 before this court passed by the learned principal Judge Family Court Kamrup and Guwahati submits that the next date is fixed on 1/8/2025 for ex-parte hearing. Ex-parte hearing. And accordingly, it is provided that the learned principal Judge Family Court shall make an endeavor to dispose of the aforementioned petition on that day. In terms of this CRP IO number 477 of 2024 stands disposed of.
Item 22.
She may have the certified copy. I may have the
certified copy, but you furnish one Xerox copy.
Lord.
This is an appeal for enhancement, Lordship. First time has come. Notice to go, Lordship.
Third, Mr. M. Khan, learned counsel for the applicant. Appellant. This appeal under section 173 within the one of the MPA 1988 is directed against the judgment and award dated 13/3/2024 passed by the learned tribunal. Learned Motor Accident Claim Tribunal, Siran. There is the memo of appeal and the grounds mentioned therein, and also there is the impugned order dated 13/3/2024.
Well, Article 22/4/2025. Judgment and order. That is the date of incident. 13/3/2000.
22/4/2025. But
Yes, 8 Lordship. 9 is
2025. Admit issue notice for the respondent returnable in courts that be taken by registered also with AD and also by equal process within a week from today. This is the for which this is a call for the record from the learned level.
24.
Wait, your Lordship. Lordship, this is a statutory appeal. Lordship, in this case, though the court came to a finding that the insurance company is not liable, but still gave the right to pay and recover. Lordship, we are against that, Lordship. And amongst that, other grounds are also there. And Lordship, we have a stay petition also.
Stay proceeding is there?
Yes, Lordship, 2279 of 2025.
But deposit 50% of the ordered amount?
Yes,
in
Lordship.
4 weeks.
Yes, Lordship.
25.
25 also, Lordship. Statutory.
Same.
No, not same. It is different, Lordship. In this case, we proved that the injured was not in the accident.
No, that's all right.
Yes, same, Lordship. Admit and 50%. Highly obliged.
26.
This is appealed by insurance company. So that case,
My lord, the claimants could not.
What is the amount?
My lord,
What is the amount of compensation?
total amount, my lord.
You have not produced the file.
Yes, my lord.
Anyway, we admit the appeal.
My
Then for staying, you deposit 50% of the
50%.
amount. Next, 27.
Right. There is a stay prayer. Stay petition is
Yes,
5285.
deposit 50%.
My lord.
57. Wait to the lordship. Also, this appeal was in filed against the finding of arrest and negligence of man.
What is the quantum of compensation?
27 lakhs, lordship, 98,840.
Why two IAs are there?
Lordship. Oh, one is for lordship, additional petition, for additional evidence to consider evidence.
Let the other side appear. We'll hear from this case. This I number 2287.
One is for stay, other is for years. Additional evidence under 41 Rule 27.
We'll hear the other side.
Yes, President.
The other IA for staying.
Two items. One is for stay, other is for under 41 Rule 27.
Deposit 50% of the awarded amount
Yes, sir.
after 4 weeks.
Right. Those, 28.
Lordship, statutory appeal, Lordship, I think same order. 50% they will deposit. Hello.
Item number 47 by VC Mode.
My lords, yesterday I wanted to show to my lords the judgment in Navary Lignite. My learned friend will be handing over a copy, my lord.
Yes. So the relevant paragraph?
Yes, my lords, just before coming to the conclusion of the court, my lord has Navary Lignite, 1995 1 SCC 221. My lord has that.
1995 1 SSA 221.
Lordship.
Yes.
My lords will directly come to just one paragraph before I take my lords to the discussion on the law. This is the internal page 224. Between placetum, my lords can read between placetum D and F.
Yes.
It starts from paragraph 2, my lords, a little lower. Thus, these appeals, my lord has that.
Yes.
It is not in dispute that the entire controversy hinges upon the interpretation of 3B, which is the definition of person interested, and section 50 subsection 2, which is the, my lords, the impleadment of a person for whom the acquisition is carried out, a company or a corporation of the act, whether the appellant is a person interested either to be impleaded as a party respondent to the pending references under section 18, to lead evidence, contest the reference, and if compensation is enhanced, to file an appeal in the High Court under section 54, or to get impleaded as a party respondent in the pending appeals filed by the land acquisition officer, or to file a writ petition under 226 challenging the correctness of the award in the decree made by the civil court. So, my lords, this is the proposition of law. Now, as I was pointing out, my lords, the landmark judgment is Himalayan tiles and marbles, which is noted in the next page, page 225, my lord.
Yes.
And at para 5 of this judgment, the relevant portion of Himalayan tiles is quoted, which is para 8 of the judgment in Himalayan tiles. May I read that, my lord? It seems to us that the definition of a person interested given in section 18, obviously section 3B, is an inclusive definition and must be liberally construed so as to embrace all persons who may be, my lords will please note, directly or indirectly interested either in the title to the land or in, my lords please note, in the quantum of compensation. In the instant case, it is not disputed that the lands were actually acquired for the purposes of the company And once the land vested in the government after acquisition, it's to transfer to the company under the agreement under so and so, so and so. Thus, it cannot be said that the company had no claim or title to the land at all. Secondly, since under the agreement had to pay compensation, and this is the important part, it was most certainly interested in seeing that a proper quantum of compensation was fixed so that the company may not have to pay a very heavy amount of money. For this purpose, the company undoubtedly appear and adduce evidence on the quantum of compensation. Now, my lords will kindly move to the next quotation, which is following. Thus, the preponderance of judicial opinion seems to be in favor of the view that the definition of person interested must be liberally construed so as to include a body, local authority, or a company for whose benefit, which is me, for whose benefit the land is acquired and who is bound under the agreement to pay the compensation. In our opinion, this view accords with the principles of equity, justice, and good conscience. How it can be said that a person for whose benefit the land is acquired and who is to pay the compensation is not a person interested, even though the stakes may be extremely vital. For instance, the land acquisition proceedings may be held to be invalid, and thus a person concerned is completely deprived of the benefit which is proposed to be given to him. Similarly, if such a person is not heard by the collector or a court, he may have to pay a very heavy compensation, which in case he is allowed to appear before the court, he could have satisfied that the compensation was far too heavy, having regard to the nature and extent of the land. We are therefore unable, my lords, that Calcutta High Court, Odisha High Court, there was some judgment, so I'm not going into that. Now, my lords will directly come to paragraph 12 at page 229. Para 12, which is at the bottom of the page.
Yes.
May I read that? It is true that section 50, subsection 2 of the Act gives the local authority or the company right to adduce evidence before the collector or in the reference under section 18, as it was specifically stated in any proceedings held before the collector or the court. My lords, I'm skipping that. Now, my lords will kindly see para 14. Because this is the example which is given by the Supreme Court, para 14. If there is no right of hearing or appeal given to the beneficiary, and if the state does not, this is the exact case which has happened here, my lords, and if the state does not file the appeal, or if filed with delay, it was dismissed, is it not the beneficiary who would undoubtedly bears the burden of compensation? Who would be the affected person? Is it not interested to see that the appellate court would reassess the evidence and fix for proper and just compensation? For instance, the reference court determined the market value at 1 lakh, while the prevailing market value of the land is only 10,000. Who will bear the burden? Suppose the state appeal was dismissed due to refusal to condone the delay. Is it not an unjust and illegal award? Many instances can be multiplied, my lords. I'm not troubling my lords. Then it goes on to say that as a necessary or proper party affected by the determination of higher compensation, the beneficiary must have a right to challenge the correctness of the award made by the reference court under section 18 or in appeal before this is before the High Court. Considered from this perspective, we are the considered view that the appellant company is an interested person within the meaning of section 3B of the Act and is also a proper party, if not a necessary party under 110. The High Court committed a manifest error of law in holding that the appellant is not a party interested, and my lords, the High Court order is set aside. Now, relying on this neighborly lignite, I don't want to trouble my lords with the law. I can show several judgments. There was another judgment which, my lords, came from the Supreme Court. This is Delhi Development Authority versus Bholanath Sharma, and reported the citation is 2011 2 SCC page 54. Here, just to give a background so that I don't have to read the judgment with the facts, my lord, DDA, my lords, was the authority. The Delhi Development Authority was the, my lords, the authority, the requisitioning authority for which the acquisition of was carried out, which is evident, my lord, from the first paragraph, the opening lines at the first, the second, the third page, my lord. The opening lines of the judgment make it very clear. I'm not troubling my lords. Para 1 and 2 make it very clear that it was the acquisition was for the DDA, and the issue was because DDA had to pay the compensation, whether it can be treated as person interested within the meaning of 3B of the Land Acquisition Act. Now, this was the proposition which was fixed, my lords, and then my lords will directly come to para 32. My lord has that, para 32.
Yes.
May I read, my lord? Section 50, subsection 2 represents statutory embodiment of one of the facets of rules of natural justice. The object underlying this section is to afford an opportunity to the local authority or the company to participate in the proceedings held before the collector or before the court for determining the amount of compensation and to show that a claim filed by the landowner for payment of compensation is legally untenable or unjustified. This is possible only if the collector or the court concerned, this is important, gives notice to the local authority or the company concerned. If notice is not given, the local authority or the company cannot avail of the opportunity envisaged under section 50 subsection 2 to adduce evidence for the purposes of determining the amount of compensation. Therefore, even though the plain language of that section does not in terms cast a duty on the collector or the court to issue notice, this is the section 20 point which my learned friend had wrongly argued, my lord, to the local authority or the company to appear and adduce evidence before the said requirement has to be read as implicit in the provision, else the same would become illusory. So the section 20 has already been read down in this judgment. Clearly, my lords. So even though section 20, as my learned friend was yesterday trying to argue, my lords, that it does not say that a notice has to be issued to the beneficiary, the Supreme Court, my lords, relying on navally lignite. I'll go further, my lords. Then, my lords, para 33, I don't want to trouble my lords. My lords has already read all the paragraphs from para 33, my lords, quotes Himalayan tiles. Para 35, my lords, quotes navally lignite. I'm not troubling my lords with the quotation. It is there. My lords know, my lords has already read it. Now, kindly come to the conclusion. The last page, para 42, serial number 4, my lord. The second last page.
Yes.
Para 42, my lords, there are the conclusions. And I'm reading, my lords, serial number small Roman 4. DDA was entitled to notice an opportunity to adduce evidence before the reference court could enhance market value of the acquired land, entitling the respondents to claim a higher compensation. And as no notice or opportunity was given to DDA by the reference court, the judgment rendered by it are liable to be treated as nullity. So my respectful submission is, my lord, that notice to me is the most essential element and it's a vital part of the land acquisition proceedings, both before the collector as well as before the reference court. My lords, it's an admitted position. It is born out of the records of the reference court, my lord, that my impleadment application, which was filed actually by the state filed impleadment knowing fully well that I have to pay the compensation, and therefore filed the application for impleadment. The reference court, my lords, in its wisdom, I do not know why it did so. I do not want to say anything more. But that application, my lords, was numbered. Objections were filed, but never heard. No, my lords, there is no adjudication on the application. And the reference court immediately goes to hear the matter and finally hear the matter and dispose it of. So my respectful submission, my lords, is that this appeal may be allowed, my lords, only to the limited extent that the matter may be remanded back to the reference court. Let the reference court hear the matter de novo. Give me all the opportunity, my lords, which is available to a party in the reference court to adduce evidence and otherwise, my lords, lead whatever evidence I'm supposed to lead or I'm entitled to lead under the law. And my lords, then the reference court can decide on the merits of the case whether the enhancement of compensation is correct or not, my lord. I rest my case, my lord. If there's any, my lords, anything that my lords want me to address upon, I'm happy to do that.
So what order was passed on the petition filed by the Deputy Commissioner?
My lords, no order. I'm taking my lords back to that. My lords will kindly come to the orders which start at page 148. On the 16th, my lords will please note the application which was filed by the Deputy Collector to implead me was filed on the 16th of February 2023. The order of that date is at page 148. The application was numbered as, my lords will kindly note that 265 of 2023, praying to implead power grid as party. That my lord sees at the top. So this is the application 265. Now, as it proceeds, my lord, if my lords will see 149, time was given, my lords, and objection was filed on the 3rd of May 2023. The order reflects that the objection was filed. It is on the record, my lords. These are all admitted things. And my lords, the date fixed on the 3rd of May 2023, it is fixed for 3rd of June 2023 for hearing on 2 IAs, which is 1937. I'm not aware what that is. I'm more interested in 265, which is the application for impleadment. Then on the 3rd of June 2023, my lord, it is again fixed for 28th of June, as at the bottom of the page, my lords will see at page 149. It says fixed on, my lords, 28th of June 2023 for hearing on, my lords, 2 applications. I do not know what 264 is, but 265 is the application we are, my lords, dealing with. Then, my lords, on the 28th of June 2023, there's an adjournment, my lords, application for adjournment is, my lords, moved. And then the matter is adjourned to 31st of August 2023 for hearing. And then, my lords, will kindly see 31st of August 2023. It is fixed for 11th of December 2023 for hearing. And then at page 151, my lords, will kindly see the next page. There was some transfer, my lords, so therefore the matter was moved. And then, my lords, it was fixed for 4th of January 2024 for hearing, which is at page 151. And then, my lords, on the 4th of January 2024, it says both party represented. My lords will please note the words both party. Otherwise, if it would have said all parties or 3 parties, PGCL is not there. Both parties, that is the landowners and the government. For final hearing, heard both sides and fixed on 3rd of February 2024 for orders. And then it was fixed subsequently for orders on the 3rd of February 2024. It was fixed for 4th of March 2024 for orders. And on the 4th of March 2024, the impugned judgment was passed. No order, no hearing, my lords, let me put it this way, let me go step by step. No hearing on this application after the filing of objections. No order allowing or dismissing the application. No notice to me, my lord. It's very clear, my lords.
Yes, madam, have you gone through the decisions referred by learned counsel today?
Yes, Lordship, I have.
Yes, so what is your submission?
Lordship, all the decisions, Lordship, the lignite, and Lordship, the Himalayan tiles, Lordship, don't cover our case, Lordship. Because, Lordship, in all the decisions, Lordship, the corporation or the company has not made party at all, Lordship. But, Lordship, in our reference proceeding, Lordship, the power grid is a party, Lordship. Lordship, kindly come to their memorial page number 43, Lordship.
Yes.
Lordship, here the parties' name are mentioned, Lordship. That is Sri Dulab Dungli and 26 others petitioners, and Lordship versus Power Grid Corporation of India, opposite party, Lordship. So, Lordship, they are implemented as a party in our reference proceeding.
That's all right. Whether notice was issued.
Lordship, kindly, Lordship, in below, Lordship, the opposite party's advocate's name is mentioned, Lordship, Mr. Pranjal Upadhyay. Lordship, he is also representing the DC.
I'm sorry, my lords, my learned friend should not speak off the record. My lords will kindly see Pranjal Upadhyay has been appearing for the Deputy Commissioner. He was not our counsel. He's not our counsel, which is, my lords, evident. Otherwise, also, my lords, during the hearing, also, my lords will kindly see. My learned friend should not speak off the record, my lords. If she has my lords, a valid point to make on the legal submissions, I don't mind, but let her not make submissions off the record. My lords, well, please see the reference orders. In the reference orders, my lords, it is very, very clear that Pranjal Upadhyay has been appearing, my lords, for the government, the deputy collector, my lords.
My lord, page 134 is the petition which was filed.
It is filed through Pranjal Upadhyay, my lord. Please see the application for impleadment. At page 139 at the bottom of the page, Pranjal Upadhyay is the counsel for the deputy collector, my lords.
Lordship, as I said, Lordship, Pranjal Upadhyay is the counsel for both Deputy Commissioner and Power Grid, Lordship. Lordship, Pranjal Upadhyay presented himself before the court that he is representing Deputy Commissioner as well as Lordship, the Power Grid. And also, Lordship, he create that image not only before the court, Lordship, but before the advocates or petitioners also. So, Lordship, if a person himself approached the court saying that he is the advocate of so and so, Lordship, then what is the need of issuing a notice? That's why, Lordship, the reference court didn't issue the notice, Lordship, as the advocate of Powergate, Lordship, he himself approached the court that he is representing the Powergate. If Lordship kindly come to the order 3, 2nd February 2024, Lordship.
Page number
Lordship, last case 158, Lordship. 158.
Yes.
Lordship, here in the 3rd February 2024 order, Lordship, the last part, contention of submission is of reference LA case number 1/2019, Learned Counsel for the petitioners has contended of objection as to the order 10 Rule 22 CPC, to which other sides has raised their intention relying upon many decisions, Lordship. Lordship, here the opposite party relied upon decisions, Lordship, they raised their objection. Lordship, in this point, Lordship, there is no need for the DC to rely upon any decisions or creating any objection, because after due satisfaction of the DC himself referred the matter to the principal civil court, Lordship. Here, Lordship, Powergate is, Lordship, present. Their advocate is present. And Lordship, the Pranjal Upadhyay, he himself argued the matter many times, Lordship, before the principal civil court. So, Lordship, our matter is totally different from all the decisions submitted by the Learned Senior Counsel, Lordship. As in our matter, the Powergate is impleaded as a party, Lordship. Despite, Lordship, we have filed the objection. That's
No, if he was impleaded, PCC was impleaded, then what is the question of filing the petition by the Deputy Commissioner for implement of PCC?
Lordship, what, Lordship? Sorry, Lordship, what you have asked.
Madam, you see, the application for implement of PCC was filed by the Deputy Commissioner.
Yes, Lordship. Lordship, that implement petition was, Lordship, filed by the Pranjal Upadhyay on 16th day of February 2023, Lordship. Lordship, till then, Lordship, there was no one for the PGCI. But after, Lordship, 16th February 2023, Pranjal Upadhyay is representing, Lordship, the power.
When?
16th day of February 2023. From the day, Lordship, they have filed the petition for implement of Powergate Corporation of India.
Whether there any order was passed by the reference court regarding representation of the PCC
No.
by the Learned Counsel?
No, Lordship. That's
Then-
why, Lordship, the petition filed by the Deputy Commissioner for implement, that petition also, Lordship, nor Lordship rejected nor allowed, Lordship, because Pranjal Upadhyay himself approached the court.
No. You tell me, is there any order to show that Pranjal Upadhyay entered appearance on behalf of PCC?
No, Lordship.
Then
My lord, we never engaged him.
can you show from the record that Pranjal Upadhyay has filed Wakalatnama?
Lordship, for government, there is no need to file a wakalatnama.
No need to file.
Yes, Lordship. And Lordship,
Can without power, one advocate can enter appearance for a party?
yes, Lordship. And Lordship, reference court proceeding is not
No. Now you tell me whether at the time of passing this impugned judgment and order,
Yes, Lordship.
the PCC was heard
Yes, Lordship. Yes, Lordship.
through advocate Pranjal
Pranjal
Upadhyay.
Upadhyay, Lordship.
But there is no order to show that he entered appearance on behalf of PCC.
Yes, Lordship. And Lordship, one thing, Lordship, if the Pranjal Upadhyay is not an advocate of Powergate of India, Lordship, the judgment was given back in the 4th of March 2024. If he is not the advocate, if he has objection, then he has to file a petition saying that I am wrongly mentioned as an advocate of opposite party Powergate of India, and the judgment may be called for and revised, Lordship. But no such petition is filed by the Pranjal Upadhyay, Lordship. That means what, Lordship? Pranjal Upadhyay is the advocate of opposite party. He admitted that fact, Lordship.
Where he had admitted?
Because lordship, he has not filed any petition yet, lordship, that he saying that he is wrongly mentioned as the advocate of opposite party in the judgment filed by the lordship reference court.
Where it is mentioned?
Lordship, page number 59, lordship.
Page number 59.
Is the first page of the judgment, lordship.
Page number 59. Where it is mentioned?
Lordship, his name is mentioned as the opposite party, lordship.
Opposite party means?
Boundary of India, lordship. The opposite party's name is mentioned, lordship. Above that. Lordship is clearly mentioned the Power Grid Corporation of India as a opposite party in Miss Land Equation Act number 1 of 2019, lordship. Lordship, if he is not an advocate for opposite party, then he has to file a petition for correction, lordship. As we have corrected the judgment, lordship.
So why no order was passed on the petition?
Lordship,
Number
maybe,
265 of 2023.
lordship, that I don't know, lordship, but that petition, implement petition was nor rejected nor allowed, lordship. The petition of DC, Deputy Commissioner for Impleading, lordship. Lordship, that petitioner was not allowed or never rejected.
What does it indicate?
Lordship.
Neither allowed nor rejected. What does it indicate?
Lordship, because the Pranjal Upadhyay, he himself approached the court and he represent himself as a advocate of Deputy Commissioner and Power Grid of India. And lordship, on some points, lordship, court can resume such some things, lordship.
What?
As lordship, he make that image, he present himself as a advocate of both the parties, lordship. So I don't think there is a need.
Here mentioning in the cost-title of the judgment does not indicate that he appears for the Power Grid Corporation of India, unless there is any Ukalatnama to show that he was engaged in that case. Can the court presume it that he appeared on behalf of the Power Grid Corporation of India? Anyway, we will pass the order. Mr. C.P. Sharma, learned senior counsel assisted by Mr. Khera.
Lordship, if lordship is going to admit the appeal, lordship, then lordship 50% amount should be deposited by the appellant, lordship. As lordship, this is a money appeal against a money decree, lordship. And lordship, they are just paid only 60,000 rupees for 8 because of land, lordship.
Just,
Lordship, our
my lord,
respondents are agreed.
I am not asking for admission of this appeal. I am asking for disposal of this appeal and the matter being remanded back to the reference court, my lord. So there's no question of any pre-deposit. There's no question of any deposit in the court. I'm on the preliminary point that I have not been heard. This is an ex parte decree against me.
Lordship, if the matter remit back, lordship, then the person, the respondents will suffer, lordship. They already have waited for 17 years, lordship. Lordship, kindly don't ignore this, that they have paid only 60,000 of rupees for 8 because of land, lordship.
Because the compensation, after all, my lords, in the
And
reference.
lordship, that is the compensation, lordship, determined by the PGCI, lordship, without any authority, lordship.
My lords, if the reference court takes up the matter de novo, all these arguments are open. All rights and contention of the parties will be open, my lords. They will have their chance. Nobody can dispute the fact that they will be parties.
State respondent, we have to clarify certain things.
Yes.
My lord, in case my lord chooses to remand the matter, we have certain reservations, my lord. This case has, the land was actually acquired in 2006. And it has gone on for 17 years. Then these 27 citizens of our state, they've been waiting, my lord, some kind of justice has to be done. And then even my lord remands, which is a fit case, in fact, I don't have objection to the remand by itself, but it should be completed within 6 months. That is very important.
I fully agree, Meloj. Meloj can even fix a lesser time, Meloj, fix 6 months. I mean,
That is the maximum, my lord.
that is a good
This
suggestion.
is something very serious, my lord.
Mr. Soma, perhaps you are aware of the judgment of the Supreme Court in the case of Allahabad High Court Bar Association, that the court cannot fix time.
I know that's true, Maloj. But now, Maloj, the Supreme Court is, Maloj, in several
now
matters, Maloj, and it is
Change, my lord, now.
Maloj, I leave it to my
many
lord.
land acquisitions are going on that it has become unmanageable for the state to, because we have to take responsibility ultimately for everything. And these things, my lord, I don't have objection to the remand itself, but this thing that this lawyer that appeared for two parties, this may be investigated when it goes back. Because something we are concerned, because he was supposed to appear for the deputy commissioner. And whether he informed the deputy commissioner at that time that he's appearing for Power Grid also.
Maloj, that
Never appeared for us. We
does
never
not
appeared.
arise.
My lord, nobody has appeared for us because we have not given, we never knew of the proceedings, and it is a statement we are making at the bar. Nobody has been appointed to appear for us, and we are a PSU, my lord, not a state. So every case to case basis, there is an engagement of counsel which happens.
And Maloj, it is an incorrect submission on the part of my learned friend that Pranjal Upadhyay has appeared for, my lords, the corporation itself, my lords, because there is no wakalatnama on record. There is no submission made. So
because that shows a certain laxness on the code itself there below.
Yes, I
So
didn't want to
that
say
is very
that.
important, my lord.
I
My
didn't
lord, the
say
High
that.
Court should take notice of that.
Maloj, I
Because
did not
we
want to
give
go
a
that
bad name to the code itself. So, and I myself, I don't want any issue to be made out of this.
Pranjal Upadhyay appeared on behalf of deputy commissioner.
Yes. So did he, if he had appeared for Power Grid, did he inform the deputy commissioner? So we don't have anything to show that.
That's because he did not, my lords. That is not born out of the records anywhere.
So my lord, the best thing is that she will be also happy. Remand this thing, no issues anywhere. Completed within 6 months, the whole thing gets over. Otherwise, there will be, because this kind of things should not go on. It's good for the court.
We'll not fix any timeline, but we'll request the trial court to, the
Expedite.
reference court to expedite the matter.
Yes, yes.
And to complete the entire process as soon as practicable.
Yes.
That observation can be.
And I from my government, because this letter dated 26/5/15 that came from Power Grid, in the future, I will see that this kind of things doesn't happen again, my lord. Because obviously the DC had to take the decision, my lord, how much the parties will be paid. And how this letter came in, and of course, it's a long time ago, but this thing should not happen again. Yeah.
My lords, I'm sorry, my lords, before my lord concludes this, I have only one request. Now the matter is coming up on the 20th, as my lords were pointed out on the last occasion. Yesterday, I pointed it out.
No, we'll pass the order.
My lords, then let them not take any steps, my lords. That my learned friend then give a statement that they are not. My lords, what has happened is, my lords, my learned friend will hand over the order which has come from the, my lords, the additional district sessions judge. It has already, my lords, the notice for, my lords, disclosure and moving forward with the execution has already come. So then on the 28th, my lords, then the execution should not proceed. My lords are reserving the order. But in the fitness of things, my lords, then my learned friend has to give a statement that they will not press the execution. Please see the notice, my lord. It has come, and the order also I had pointed out. Order of the 21st, my lord. This is pursuant to the order, my lord.
Mr. Sharma, one petition can be filed before the learned before the court of learned additional district judge Vishwanath Sayadi.
My lord.
That this appeal is pending here.
My lords, we've already said that. Despite the, my lord, this is the problem now, my lords. We have already filed an application before the executing court. That, and despite that, my lords, the order of 20th of June was passed. My lords, will please see the order of 20th of June. This is why I am concerned, my lord. Please see the order of 20th of June 2025, which is passed by the executing court, my lord. This is very alarming. We pointed out, we filed an application, petition.
Mr. Sharma, you say the Supreme Court has fixed the timeline
Yes.
for execution of the decree within a period of 6 months.
6 months, my lords. Yes, my lord.
So otherwise, the presiding officer has to fetch the music,
Yes.
the departmental proceeding.
But my respectful submission is that the judgment will not apply in a case where the High Court is active.
Anyway, we will pass the order on that day.
My lord, I'm
28.
so deeply obliged, my lords. I'm deeply obliged.
Next.
I'm speaking for respondents 2 and 3.
Okay.
48.
My lord, N. Khera, assisting. Highly obliged.
48.
This case, my lord. This is agreement succession case, my lord.
Okay. Heard Mr. A. Rosset, learned counsel for the appellant. This appeal under section 384 of the Indian Succession Act 1925 is directed against the judgment dated 3rd of April 2024. First name is succession case number 6 of 2021, first by the learned additional district judge Borpeta. It's to be noted here that by the judgment and order dated so and so, the learned additional district judge Borpeta has rejected the share of the appellant in the property of her husband, late Sirazul Haq, who suffered demise on 14/1/2019. There is a memo of appeal and the grounds mentioned therein. Also, there is the impugned judgment and impugned judgment dated 3rd of April 2024. Admit issue notice to the respondents, returnable inquiries that be taken by registered post with AD and also the usual process within every month today. Justice will call for the record the learned for the court of learned additional district judge Borpeta. Please the matter of third for it.
My one prayer, my lord. In the meantime, my lord, impugned order mechanically state. Otherwise, the amount is 9 lakhs, my lord, 49,000. If they taken away, my lord, my share will go. So the impugned order mechanically state.
Today IA has not been listed.
Oh, IA was filed for delay. In this case, I have not filed any IA. You will write. Anyway, then I'll file IA.
File an IA, then we will see.
Item for hearing under order 41.
Non-attest for the appellant from call this matter. Mr. Sohan, let it be on another date.
My lord, on 5th
Time is
August.
about to over.
5th of August, my lord.
5th of August.
Yes.
Okay. Let's just list the matter on 5th of August.
31.
Kusami? Another day.
Next week, Lordship, the urgency is there. Next week, Lordship.
Okay, next week. Okay.
On 4 August.
Let's just list
Next
the
week,
matter
Lordship.
on 4th of August.
Urgency is there. Execution is going on, Lordship.
Next week.
Next.
31st August.
When the next date is fixed?
7th August.
7 August.
7 August. Then before 7 August, we will take it up.
4th August.
Obliged.
For orders, 32.
May I appeal the lordship? My lord, here the case is only 17 days delay in filing the regular second appeal, my lord. And already, my lord, newly such legal here, my lord, we have served the notice for Dusty, my lord, and they refused to, my lord, accept. So we have already filed our affidavit, my lord. So service is technically completed, my lord.
Yes, any objection?
I am for respondent number 34789
10-3 to 10-9.
3, 4, 7.
3, 4, 7, 8, 9. 10-3 to 10-9.
After 10,
After 10-3, 10-4, 10-5,
10-3,
10-6, 10-7, 10-8, 10-9.
10-3, 10-4, 10-5, 10-6, 10-7, and 10.
10-8, 10-9.
Okay. Any objection in condoning the delay?
No, my lord.
No objection.
No.
Heard, Mr.
K. Sinha, my lord.
Yes, learned counsel for the applicant and also heard Mr.
M. Hussain. M. Hussain.
M. Hussain, learned counsel for the respondent number
3, 4, 7, 8, 9, 10-3, 10-4, 10.
Yes, we have noted down.
Yes.
This interlocutory application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 17 days in filing regular second appeal. Mr. Sinha, learned counsel for the applicant submits that. What is the ground?
My lord, when this engaged counsel was engaged by the parties, the father of the engaged counsel, engaged counsel, my lord, in the meanwhile expired. So due to that, my lord, the engaged counsel, my lord, went to his native place, my lord.
Submits that. But the
My lord,
father of the
Terati.
engaged counsel suffered demise for which the engaged counsel could not take step in time. And when the appeal was prepared and filed, then 17 days already their occasion delay of 17 days, and that the same is not intentional, rather it is circumstantial, as therefore Sina is contented to condone the same. The learned counsel for the respondent number so and so submits that he has no objection in the event of condoning the delay of 17 days in preparing the regular second appeal. Having heard the submission of learned counsel for both the parties, I have calculated onto the petition and the documents placed on record. And also there is the statement and environment made in the paragraph number 3 of the application. And it appears that the delay of 17 days in preparing the connected regular second appeal is sufficiently explained. And on such count, this court is inclined to condone the same. In terms of this IA instance dispose of. In view of the order passing the IA numbers, so rest will proceed to register the regular second appeal and place the same before the court as soon as practicable.
My lord, my concern is they have already proceeded with the execution, my lord. So 28th of this month is fixed for steps. So lordship,
But unless the second appeal is registered and placed before this court, we cannot pass any.
my lord, so my prayer is, my lord, let the second appeal maybe fixed on 30 so that we can.
Register will register it as soon as practicable. We cannot issue direction. You go and file an application before the registry to list it as early as possible.
My lord.
May it your lordship. My lord, I'm appearing for the first time in this matter, my lord. The copy of the RFM will be served to me by the petitioner.
This application, IA.
Lord's RF here, lordship. I copy had been
Only-
served. That's why I'm coming to know that the
Memo,
matter
sir.
pending. The RFA petition number 99/2017 is not served to me. It's a all pending matter. There's a direction also to provide a copy from this honorable court.
Okay, part Mr.
Video relative.
Learned counsel for the appellant and this MD Bora.
Bora, lordship.
Learned counsel for the respondent number
1, 2, and 4, and standing counsel transport department.
I'm looking for respondent 1, 3, and 4.
1, 2, and 4. Here.
3. 3.
Mr. Protestant for respondent number 3. Ms. Bora submits that she has not been furnished a copy of the memo of appeal. The learned counsel for the appellant undertakes to furnish a copy of the memo of appeal to Ms. Bora during the course of the day. Available with you. Whether the record has been, LCR has been received. It appears from the order dated 1/8/2018 that the LCR has already been received. And in that way of the matter, SSL is the matter for hearing on
On 16 September.
Lordship, I'm with you.
Yeah. This IA is for?
Bringing on some additional document, Your Lordship. Additional notification of the government of
You
Assam.
want to file objection or will dispose?
Lordship, Lordship, in the IA, Lordship, they bring some notification, Lordship, for education of the matter, my lord. It will help my lord to decide the matter.
Connected with the state of Assam, my lord. Actually, general notifications issued by the state. So those may not be directly connected with the actual case in the lower court, my lord. Actually, in the appellate stage, they are trying to bring in certain new thing, which is not allowed in civil law. These papers are actually.
Anyway, if you file objection, we will say.
Yeah.
You have not filed any objection. Part Mr. So-and-so learned counsel for the applicant. This application under order 41, rule 27, read section 151 of the Code of Civil Procedure is preferred by the applicant for allowing the applicant for adducing additional evidence. Let a copy of the application be furnished to the learned counsel for the respondents. Then list the matter on 6th. In the meantime, the learned counsel for the respondent may file their objection.
Lordship, I'm with you.
35.
Please, Your Lordship. Office note speaks that Lordship, neither ID card nor unsubmitted notice has returned back, Lordship. But Lord, now I have checked that in the system, Lordship, they have filed a Ukalanama on today itself, Lordship. This is not on record, Lordship.
Art Mr. Art Fukan, learned counsel for the petitioner. Mr. Fukan submits that one counsel entered appearance on behalf of the respondent by filing Ukalanama. In that way of the matter, it is provided that SSL put up a note indicating whether any counsel entered appearance on behalf of the respondent and file by filing Ukalanama. List one.
And next date is on 13/8, Lordship, before the trial.
13.
I will wait for the respondent today. File parliament.
Today. Okay. Letter on Mr. Learned counsel entered appearance for the respondent. Yes. You want to file objection here?
Lordship. 4 weeks time will be granted, Lordship.
The learned counsel for the respondent submits that he may be granted some time to file objection. There is allowed, this is a less than matter after 2 weeks.
So next date fixed on 13/8, Lordship, before the trial court.
13/8.
13, Lordship.
Okay. 2 weeks will be covered in between.
Lordship.
36.
Obliged.
May I please, Your Lordship? Lordship, in compliance of the previous order, we have taken steps upon the respondent, the sole respondent, but as per the office note, the address would not be found. So we would try to ascertain the correct address again and take fresh steps.
Third, Mr.
F for the Lordship.
Learned counsel for the petitioner. Office note dated 23rd/7/2025 indicates that the notice issued to the respondent returned answer with a report that the report of the process server that the sole respondent would not be traced out in the given address. given address. In that way of the matter, it is provided that the learned counsel for the petitioner shall obtain necessary instruction and take best step upon the respondent by registered post with ADN, also by usual process within 1 week from today.
Lordship, yes. Lordship, one more thing is that there is an execution case pending and the next date is 1/8. Moreover, for the respondent, the counsels are appearing before the lower court. Before the executing court, the counsels are already appearing. So if
That what is this that case is pending?
it's in fine
Execution case.
executions, it's the writ has not been issued, but I guess
Perhaps there is no prayer for staying the judgment.
stay place proceeding should be Lordship, 22 page number.
If a writ is not issued, we will see. Like that. They will take step.
I'll text it. Much.
38. May it please the Lordship. Lordship, IA 1920 Lordship. At annexer, kindly see annexer 1 at page 12. My lord, this execution proceeding, kindly note the date, Lordship. Execution title execution 2 of 2019. And in connection with this 2 of 19, this notice was served dated 19 May 25, fixing the date on 3/6/25. And we appeared before the executing court and we filed this Lordship, this petition at annexer to page 27, saying that this matter is pending before this honorable court. So order may be stayed. Now, after hearing both the parties, this order has been passed, rejecting our distinct Lordship, prayer for stay. And writ also issued and that is fixed on this 29/7. So, my lord, my limited prayer till disposal of the delay condonation petition, this may be stayed. And Lordship, they knows, other side knows. In order also it reflects that High Court's case tendency of the High Court's cases, still they are not appearing here. So my prayer is at least still disposal of the delay condonation petition, Lordship, it may be stayed. Because writ has been issued, Lordship. And our High Court one judgment is also there, Lordship, under 151. In such a situation, Lordship, execution can be stayed if even if
That
delay.
is of whole
Lordship, I know.
yeah.
But Lordship, here in this case, Lordship, kindly see, it is a case of 19. And notice is served on in 25, Lordship. So they can wait for till 19 to 25. So only few days, Lordship, till disposal of the delay condonation petition, Lordship. If delay condonation petition dismissed, then this order will also go, Lordship. That is my humble submission. Otherwise, Lordship, if
No, in other cases, we have not granted such relief before admitting the appeal.
but yes, Lordship, but there they have appeared in this, they knows that case is pending. And they have argued before the executing court in this case, Lordship. Still, Lordship,
We
if it
cannot
is,
take cognizance of their appearance before the.
Lordship, interest of justice, Lordship,
No.
because writ also issued, Lordship, on 29th.
Art, Mr. Jayadekar, learned counsel for the applicant.
I filed this under section 150 on, Lordship, since the order 41 rule 5 is
This
not raised.
application under section 151 of the Code of Civil Procedure 1908 is prepared by the applicant for staying execution proceeding. in title execution case number 2 of 2019. Pending before that was of learned civil a single division. It is to be noted here that though this interlocutory application is preferred in connected RSA of RSA, which indicates serial number 3259 of 2025. Yet the said RSA is yet to be admitted for hearing. On the other hand, Mr. Data, learned counsel for the petitioner submits that the learned executing court has already issued writ and fixed the matter on
29. 29/7 this Tuesday, this Tuesday.
29/7/2025. 2025.
Issue writ of possession, Lordship. Possession, writ of possession, that is the difficulty, Lordship.
Under the aforementioned facts and circumstances, it is provided that the learned counsel for the applicant shall file an application before the learned executing court for staying the execution case till disposal of this interlocutory application. And on such petition being filed, the learned executing court shall consider the same in accordance.
I'm deeply obliged, Lordship.
39.
May I please, your Lordship? Lordship, I am appearing for respondent 1, 2, and 3. And Lordship, and I am praying for some time to file our objection in this I for delay.
Heard, Miss?
Yes, to the Lordship.
Learned counsel for the applicant and Mr.
Arbora.
Arbora for the respondent.
Yes.
Opposite party. The learned counsel for the respondent opposite party submits that he may be granted some time to file objection in this application. Where is accordingly allowed, basis shall list the matter. After 1 week.
Lordship, kindly grant 3 weeks time.
No. 2 weeks. After 2 weeks.
48. Obliged, Lordship.
Lordship, in this our prayer is to Lordship, state of further proceedings of the Lordship Bakija case, Lordship, 89/24. They are under charge of arresting the official of the company, Lordship. In this case, Lordship, 2 vehicles are involved, and after evidence, it was found that the victim who was driving the vehicle was not offending. We are the insurer of that vehicle, Lordship. But erroneously, Lordship, liability is imposed on the present appellant, Lordship. We are ready to deposit, Lordship.
What it says the MSc appeal is pending?
Lordship, MSc appeal was dismissed for default as our name was not shown. Then we filed one petition, Lordship, 3772 that is pending. Lordship,
Whether it was restored to file.
there was delay. So delay petition step was taken as per direction of the court, but that is service is not complete, Lordship.
Then
Lordship, under 151, Lordship.
Because the MSc appeal is not before the court now.
Yes, Lord, that is true, Lordship, but under 151, Lordship, we are ready to deposit entire amount, Lordship. Otherwise, Lordship, interest of justice will be, Lordship, defeated, Lordship. Our vehicle is not offending, Lordship. So they are going to arrest, Lordship, our officials, Lordship. We are going to deposit entire amount before this registry, Lordship. Before this registry, but not to be released, Lordship. Because our vehicle is not offending at all. It was found after evidence. But erroneously, we are held liable, Lordship. We are deposit entire amount, Lordship.
What to have pursued the appeal?
Lordship?
Why it was dismissed for default?
It was dismissed for default because our name was not shown, Lordship, in the cause list, Lordship. That is in the record, Lordship.
You served the notice by Dastimot. We will see. Partner is a Soikia learned counsel for the applicant.
Till then, Lordship.
No. This application under section 151 of the Code of Civil Procedure is prepared by the applicant for staying. The Bakiza case number. What is the number?
89 of
89 of 2024 within the admissibility. Let notice be issued to the respondent. Returnable on when the next date is fixed in the Bakiza case.
Lordship, there is no negative please, Lordship. They are only insisting that you bring the stay order, otherwise we will arrest you, Lordship. There are some,
Whether in Bakiza case they can arrest your official.
they will, Lordship may be pleased to go to Lordship 23, 24 page, Lordship. We have annexed, Lordship.
No, you tell me whether in a Bakiza case the
Arrest of warrant,
executing
Lordship.
officer can arrest you.
Yes, Lordship. Arrest of warrant may be issued, Lordship. They may be put in civil prison, Lordship. In the officers.
No,
Lordship.
to put you in civil prison, there must be an order. Where is that order?
From Bakiza office, Lordship.
No, from the court. Yes.
From the Bakiza office, there is no such order till now, Lordship. But they are
Then
really saying that we are going to arrest you,
no.
Lordship.
Let them arrest you. We will see.
Lordship, that will cause,
If they
Lordship.
can.
Lordship, that will cause harassment to the officer, Lordship.
And who is responsible for the same? Your officers. They have failed to pursue the appeal. They have failed to deposit the amount also.
Lordship, that is
Whether the
because,
other parties, the victims are not harassed.
Lordship,
By you people?
in this case, Lordship, our name was not shown in the cause list for we could not appear, Lordship.
Then how liability was fastened upon you by the tribunal?
Tribunal, Lordship, that is the error on the part of the tribunal, Lordship. It was held that our vehicle.
So notice returnable in 2 weeks. Step be taken by registered post with ADN also by usual process within a week from today. Justice service is also permitted after causing effect of the after effecting service upon the respondent by Dastimut. The petitioner shall file an affidavit before this court. Please submit her
On 14th August,
Till then, Lordship, maybe still, Lordship.
41.
Wait, please, your Lordship. There is a delay of 10 days listed first time, Lordship. I think notice will go much.
returnable in 4 weeks.
Hello, bless you.
42.
Make please, your Lordship. Lordship listed for the first time. This I is for condonation of delay.
How many days?
Here we have written 21.
Pardon?
21 days.
21 or 20?
Lordship, in our office copy, we have not corrected. Actually, we have corrected in the court record.
43.
Same Lordship, first time.
Same return.
44.
Lordship, same one, first time.
45. 45.
Non-appearance for the applicant on call. Please submit her after 4 weeks. After 2 weeks.
49.
May it please your lordship. My lord, I am for the petitioner.
Mr. Singh is about 5 o'clock.
My lord.
About 5.
My lord, any other day, my lord.
My lord, your lordship, you fix the date on my lord, because my lord, the case is my lord urgency because the main my lord, the counterclaim is still my lord standstill because of all these cases. So my prayer is my lord, that may be fixed on Monday, my lord, or Tuesday, my lord.
Is it hearing matter?
My lord. Because my lord, the as-parte order, last order 25/6, my lord, is not maintainable at all, my lord. This is the certified copy has to be produced before your lordship. I have already furnished to your copy, my lord. So as per this, my lord, the last order is not maintainable. Definitely dispose of them. Use the while. On 29th.
Okay, as agreed by learned advocates of both the parties, rests shall raise this matter on
29th.
at 2 o'clock.
Must.
Bye.
Your Lordship. Also, Section 5 of the Limitation Act petition for condoning 137 delays, Your Lordship, for preferring in matrimonial appeal, Your Lordship.
We are agreeing for the first time, we will file the objection, Your Worship.
Your Lordship.
3 weeks time may be granted, Your Worship.
Your Lordship, we do respect Your Lordship because the main case is for execution. Already distress warrant has been issued, Your Lordship, in the lower court, Your Lordship. But if Your Lordship, 137 delays, this was not even on the guilty, for the guilty of the
If
petition.
he wishes to file objection, let him file. We'll fix a short date.
Short date, Lordship.
Third, Ms. Zivora, learned counsel for the applicant, and Mr.
T. Gugoi.
Learned counsel for the respondent, Mr. Learned counsel for the respondent submits that he entered appearance today and he may be granted some time to file objection. That is allowed, rest is the matter on
8 August.
8 August.
I'm sorry, Lordship. Court, I have some problem with 1st of August, Lordship.
Which matter?
I think 31. Or Lordship on 29. I have some problem, that is your Lordship.
On who is that?
1st of August, Lordship, or 29, 20, 30 or 1st of August.
1st August.
1st of August.